The I goes is similar order for this review petition in view of order passed in IA Civil 1148. This review petition stands dismissed from the door. Same order in both. Same order in both. There's one more I. Two more I.
Daily list item number 1, motion BM.
Lordship, this is a bail application, Your Lordship. Your Lordship, it was filed earlier. Your Lordship has rejected the bail application earlier, Your Lordship. Your Lordship will find the rejection order on page 28, Your Lordship. Your Lordship, earlier it was a combined bail application, Your Lordship, filed by two petitioners, Your Lordship. This time, Your Lordship, only one petitioner has applied for the bail, Your Lordship. Your Lordship has, Your Lordship, the accused herein, Your Lordship, the accused petitioner herein was initially not an FIR name accused, Your Lordship. He was not at all related with the
Okay, let me
dispute.
call for the records of the other case because the case diary scanned copy of the case diary is there. We'll take it on Friday. You're the APP in the matter. Both sides are duly represented. As the scanned copy of the case records are available in connection with BA 3679 of 2022. Does this matter on 28/4/2023 along with the records of BA 3679 of 2022.
Thank you.
Item number 2 for admission.
Yes, Mr. Mazumdar. There was a query as to whether the second grade 4 employee, if the post exists in the school or not. That is the query I posed on the last occasion. Can you get that information?
Lordship will have it in the afternoon, my lord. I can have the information.
Okay.
Unfortunately,
The
this
name of the school is
escaped,
Janta High School.
my lord, yes, this escaped my notice. Unfortunately, whether the
It's okay.
instruction has come on, I just
No,
find out.
because this was not to you. The question was to the
My lord.
Education Council. Okay. Then. You want the second file?
My lord, for the instructions on this, I'll just take the note of the order and send it.
Okay, 2.
Please, sir, in this case, my lord, we have filed an IA, my lord, which has already been numbered as 1013, but that same has not been.
What is this IA for?
I for amendment in the prior petition. Amendment in the prior petition in respect of newly implemented respondent number 10, my lord. The respondent number 10 has already.
File an interrogatory application for amendment of the prayer. So we said IA is not on record.
Yes, ma'am.
List on, give a date of Friday, 28/4. No, The 28 for, along with this said I expect. Okay.
11,
Can it be taken up after some time?
After some time, Mr. Chaudhary. You want it after some time, can you?
মাটি দিব লাগে not the whole thing is disturbed.
It's okay, if you can give your
And
convenient time,
I'm
we'll take it
here
up.
for some
then.
time. My lord,
If you can give your convenient time, you can take it up then.
no, কিমান দেৰি লাগিব?
অলপ সময় লাগিব আহি পোৱা নাই
আহিব দিয়া। No, I'm waiting, my lord.
step number 4 for health.
Yes.
My lord, petitioner before your lordship has been served with a show cause notice and thereafter was suspended on grounds after sergeant giving article of charge. Petitioner at that time of during his suspension, my lord, was appointed as director of Arunachal Institute of Tribal Studies at Arunachal Pradesh, my lord. My lord, the challenge made by the petitioner in the instant writ petition, my lord, was with regard to the show cause notice, which has been served upon the petitioner. The second, my lord, with regard to the inquiry committee, my lord, initially there was a 3-man inquiry committee and there,
Just a moment.
my lord.
Yes.
My lord, the challenge of the petitioner, my lord, was with regard to the show cause and thereafter the constitution of the 3-man committee and thereafter the constitution of 1-man single committee, my lord. My lord, before proceeding, I would like to show on record, my lord, there was a order of this honorable court dated 7/5/2019, my lord. Seven five 2019.
Yes.
My lord, at the second page, my lord, the last second paragraph, my lord, the honorable court has also directed the respondent university to place before the relevant act and statute of the Rajiv Gandhi University, on the basis of which the executive council constituted the 3 members committee to initiate the inquiry pertaining to the allegation of sexual harassment against the petitioner. My lord, that has not been served to me, neither it has been brought on record, my
No,
lord.
even if it is not there, that Vishaka gives the guidelines.
Yes,
That
my
was
will-
long
which will
before it
follow.
was produced.
No, but
Act is
still,
also
the
there now,
Vishaka
it's
says
not
that
relevant.
Yes,
it has to be by a committee,
Yes,
which
my
should
lord.
be, we should have a female member.
Yes,
So that is another Vishaka.
yes, my lord.
And
But-
that has been incorporated in almost all the, what you call, disciplinary proceedings where there is a allegation of sexual harassment.
My lord. No, my lord, from my lord's knowledge and own.
It's okay, we'll take note of it.
perhaps, my
My
lord,
lord.
this writ petition is become infructuous, my lord. Because they have silenced the show cause notice. As per the show cause notice, departmental proceeding was held. He has appeared, objection was also filed. Everything in the final stage, when it was submitted to the VC for necessary action, then they have filed this writ petition. Kindly see the pair, my lord.
No, you see, if the status has not changed, how it becomes infructuous, the same status
When a
remains.
pair portion, my lord, subject to correction, my lord, page 36.
Yes,
Yes, my lord. Sorry, writ of sorcery shall not be issued declaring the impugn departmental proceeding and consequence. Show cause notice dated 10/6/2013, Annexure C, issued by the respondent authority, more particularly respondent number 1. to which
Mr.
legal
Gary,
non-
let me ask you a question. In a disciplinary proceeding,
Yes, my lord.
the initiation is by way of issuance of a
Yes,
show
ma'am.
cause notice, right?
Right.
And it culminates in the final order of the disciplinary authority.
Right.
Correct. Now, please tell me, if before any adjudication is done by the disciplinary authority, if one wants to challenge it, will he not have to challenge the show cause notice?
No, he has to challenge the show
Then
cause
how
notice.
it becomes
But
infructuous?
pursuant to the show cause notice, evidence, everything has been, and he has also participated in the departmental proceeding.
No, but
And
still,
when it was
no,
submitted,
take a particular stand.
yes,
I have made my question very clear. How does it come, how does it start and when does it culminate? Okay. See, before culmination of the proceeding, if somebody wants to challenge, is it your stand as a officer of the court
no, sir.
that show cause notice need not be challenged?
No, it has to be seven.
Then,
It's start from the show cause notice, but
then please
my-
allow her to continue.
Yes.
Correct. You make your submission because this, if you are distracting the court on this submission,
no, my-
I don't find merit in your argument.
it's okay.
Yes, yes.
My lord, I take your lordship directly to the article of charge, my lord. On the
So
main
those
ground,
things are not required.
my lord, the challenge made.
You'll have to show us that this, what you call the, whatever proceeding has been drawn against you
My lord,
is unfair, improper or invalid.
my lord, I have challenges on, my lord, with regard to article of charge. I have pointed, my lord, before your lordship, because there is a criminal crime pending in which the article of charges are same with regard to the article of charge and the procedure in trial. Initially, the defense was that the defense will be, if the article of,
Ms. Burma, please tell me, I have a query to you.
my lord,
In the criminal proceedings,
my lord,
is the departmental proceeding a part of the trial?
no, my lord,
No. Now, second question is,
my lord,
if the departmental proceeding is not a part of the criminal trial,
my lord,
how can you be prejudiced if a department proceeding is going on? You see, I have a question because of some reason.
my lord,
Number one, in a criminal trial, the trial will proceed only on the basis of whatever is available in the case diary. So a public prosecutor, while dealing with you as a accused,
my lord,
cannot put questions to his own witness unless he declares him hostile. He can't lead evidence,
my lord,
correct?
my lord.
So if he can't lead the witnesses, how can he bring that element of criminal, what you call this, departmental proceeding in a criminal trial?
My
You
lord,
see, I have respect to all the judgments, even by the Supreme Court or by this court.
my lord,
But please tell me how you are prejudiced.
my lord, when,
There can be only one prejudice which I can understand. Number one, you say something in the in a proceedings of a disciplinary proceeding, which you feel will affect you in the criminal trial.
my lord,
Correct,
my lord,
but that is not permissible. If a criminal, if you see, supposing you are a APP, can you ask a question which is not there in the case diary? Can you ask to a witness any question which is not there in the case diary?
my lord.
No.
My lord,
The second part is, you see, there is only one answer in the criminal procedure code by which a proceeding can be brought, a departmental proceeding can be brought to the notice of a criminal trial court. But I can assure you, except perhaps two senior counsel sitting behind. I can tell you, nobody in the courtroom can be present, can tell me the provision by virtue of which in a criminal trial, proceeding which is not there in the criminal trial can be brought into the notice of the court. There's only one provision. And there also it is this court, a single bench of this court has held that the said provision can only be invoked when the accused, he comes on the dock. And definitely the accused will not come and bring a record which is adverse to his own what you call interest. If he's departmental proceeded against. Therefore, you'll have to just show me that the departmental proceeding, even if he continues in between the criminal trial, how will it prejudice you?
Yes. My lord, here, my lord, with regard to the, my lord, there is no bar with regard to the continuation of the DP and the criminal proceedings, my lord, with due respect. My lord, here the DP, with
No,
regard to.
in fact, there are judgments which says that in a criminal
that's-
trial,
yes,
the proceedings will what you call has to be stayed.
yes.
But my question is based
Yes,
on
my-
based on the fact that
Here, my
in a
lord,
trial.
Yes, my lord, here the question, my lord, with due respect to my lord's question, my lord, here, it will, my lord, though death stage has crossed by 313 already, with death stage has gone by because defense witnesses are given. But my lord, with regard to my lord's query, if that would have been the stage, my lord, here is a case, it's a completely disputed facts, my lord. If my lord, departmental proceeding would have continued at that stage, my lord, the petitioner was bound to submit his defense before the departmental proceedings. Because the question here was that at the time of the incident, the victim was all alone. The case of the
But
victim.
tell me again,
At
same
the-
thing, a reverse question.
Yes,
In a departmental proceeding,
yes, my lord.
can they call for the record of a criminal
That-
trial and then
That is the challenge because the questions that.
no,
have
can they
been-
do it?
No, my lord, they cannot do it, but the petitioner to say, in the interest of his departmental proceedings, he have to bring his defense, or else his case would have gone there also, because the article of charge are on same and identical and similar factions, and that has already been before the trial court.
So that's what I am asking you this question. You see, the question is common, but the roles are reversed.
Yes,
Number
my lord.
one, in a criminal trial,
Yes, my
how
lord.
will you get the records of a departmental proceeding? And in a departmental proceeding, how can you get the records of a criminal trial and prosecute you?
My lord, if the departmental proceeding, it would have been proceeded at that stage of time, my lord, it might have ended, which
No,
would have
it's
been,
not a question. That's how,
Yes.
please tell me, how can it be brought in?
my lord.
Let us say,
that-
no,
yes,
let us say that a man has, government servant has murdered someone,
My lord,
correct?
my lord.
Now, he is tried for 302 or whatever sections are there. In a departmental proceeding, he is being tried that his action was unbecoming of a government servant.
My lord.
Now, in this case, let us proceed from the Supreme Court judgments where it says, even this court judgment where it says that defense will be disclosed, and therefore the departmental proceeding has to be stayed. We'll proceed from there. Now, please tell me, how will that be effective?
My lord,
A
if,
PP can't ask questions, he can't lead witnesses. So therefore, a APP, even if he has the records of a departmental proceeding, he can't ask a question. Look, in the departmental proceeding, you have said that. Because that would be a statement which is not a part of the judicial trial of any other case. And therefore, that cannot be imported. There's a specific bar under the Evidence Act. What sort of records can be brought in? And the previous statement of the accused,
my
he
lord,
must be put to notice.
my lord.
So how will in the criminal trial, a witness will bring his own records?
My lord, here, I'm not on the petitioner, my lord. If the defense would have disclosed, my
No,
lord.
beta, that's what I'm asking you.
If they have,
Let us assume that a criminal trial is going on. So with your statement, it would be a case where the witness out of his own accord brings the departmental proceeding record and he places before the APP. The APP will then introduce that in the evidence against the petitioner.
My lord, with due respect, here my case is not on that. My case is that the victim will take the benefit of that stand of mine.
How can it,
My lord,
how can
because
she do
while,
it?
while taking the examination in chief, my lord, there's always an open question that you have anything to say. In that, the defense, because here the main primer crux of the case was, my lord, one submission may be allowed, there was that the victim was all alone with the petitioner. The case of the petitioner was that the wife was present. So if that would have been disclosed in DP, the same would have been benefited to the victim, because always your question in examination is if
Please
it's
tell me
open.
how? Who will
Examination
introduce
is
that
if it's
evidence?
open that you have anything to say.
I understand, but you
it-
see, with some limited experience I have in trial, I'm just trying to
No,
learn.
my lord,
I'm just trying to learn, how will that part be brought in the evidence?
because my lord, it
How
is
somebody
always
has to
open.
introduce it,
It is
how?
My lord, it is always open for the victim to state anything in examination in safe, because a common question is asked, my lord, always that what you have to say. In that, if the party, because you're only.
Then you should be very happy if somebody, if the witnesses say something which is beyond the statement made under 161. I think you, as a defense counsel, you should be the most happy person to just bring on record
My lord,
that part, accost him with the statement made under 161 and say that you are introducing something which is not on record. That's what I'm asking. You see, with full respect to the judgments you are trying to cite,
my lord.
my question is that how will you be prejudiced? That is the only question I'm asking.
That is the only answer I have. The only difference, but that stage has gone by, my lord, because DWs were taken now. That stage has gone by, I have made fair submission, that stage has gone by now. Because DWs are taken, only the argument and the judgment is left behind. That stage has gone by, but at that stage, my lord, that was our defense, because this was a case completely on defense also. Before the trial court, because we have to give our defense in that. That stage has gone by, my lord, with due respect. And
Mr. Kane Chaudhary, I'll just take a, what do you call it, advice in the matter.
My lord, I was listening to your lordships and the engagement. I think lordship has not read Paul Anthony Jack.
I've seen that. That's what I'm saying. With respect to that.
But my lord, there is one more caveat. The charges must be same in both the proceedings.
No, I agree. The charges are same. We'll presume with that. That's what I'm saying. We'll
Same
presume.
set of evidence.
We'll,
There are two judgments, my lord. Paul Anthony was followed in J.M. Tang versus State of Gujarat.
yes.
These are the two judgments.
No, that's why we'll proceed from that stage only. Where the same set of charges, same set of evidence is there. That's why I gave the example of 302. One is unbecoming of a government servant because he has murdered. And one is that he is facing a criminal charge for murder under 302. Same set of witnesses, same set of evidence. If a murder has taken place in the office, same, we'll presume with if she's right. The same set of evidence. But my query is based on that theory of prejudice, because you see in a criminal trial, assuming that X is a witness.
So I think in this case, what my learned friend was submitting, that stage is over. Even DW2 is also.
No, even I'm just trying to understand the.
No, my lord, according to the Supreme Court, only prejudice is, my lord, if one is to disclose the defense in the disciplinary proceeding, it will naturally have an adverse effect on the trial where she has to take
I'm
a
considering
defense.
from there only. That is the
Yes.
query.
Yes.
You see, that's why I gave that example. APP cannot introduce something which is outside his brief. There is only one provision in the CRPC. With all respect to both of you, Mr. Chaudhary.
I think,
We
my
have-
lord, article constitution. I think sub-article 3 will also come in the way, my lord. In that case, I'll be leading evidence against myself. Article
But
20.
that can't be brought in the criminal trial.
Yes.
That piece of evidence,
Yes.
assuming that you admit the petitioner, he admits in the department proceeding, yes, I have committed a murder. Let us say, for an example, we're going to the extreme. Even if that is admitted, but my query is, how would that piece of evidence be brought in a criminal trial? Because that is not a part of the investigation.
I think, my lord, lordship will have to understand the Supreme Court view from a limited perspective. That is, it is not that disciplinary proceeding can never be gone into in the same facts. All that Supreme Court says is in such an eventuality, the disciplinary proceedings should be deferred. Supreme Court never said,
No, it's not right.
Ah,
You are absolutely right.
yes.
You're absolutely right. But that but my query is, you see, academic for that limited purpose. In a criminal trial, we all know that it is only the case diary. The materials available in the case diary can be used for the purpose of a criminal trial, because if a notice is not given to the accused person on the evidence which has been is to be led, that is hit by
Evidence Act
the
itself
evidence it provides it. So therefore, in my understanding, or with all respect to all the judgments which can be cited in this case, including Paul Anthony, you see the theory of prejudice in practical aspect, when we really face the trial, then I find that this is something which can't be imported. There's only one provision in the CRPC. It's only for your eyes. Because others will have to what you call, read and understand. So to you and to Mr. Chaudhary Senior, Mr. M.K. Chaudhary, I can disclose this, but
GM Bank to be sir. GM Bank will have a dash. State of Gujarat, 2005 case. My lord, in the later judgment of GM Tang, what had happened? In the disciplinary proceeding, my lord, there was a finding of guilt and their punishment awarded. In the meantime, my lord, the person GM Tang, he got an acquittal. Yes.
first one.
294.
But yes, you are referring to that.
Yes, in GM Tang, what happened, my lord? There was a disciplinary proceeding and criminal prosecution on the same set of facts, same set of witnesses, etc. My lord, in the disciplinary proceeding, he was found guilty and punishment awarded. In the meantime, my lord, the criminal case which proceeded on the same set of facts, he got an acquittal. Therefore, the Supreme Court says it will be unjust and onerous to find, I may say, guilty, because in a trial where the standard of proof was beyond any reasonable doubt, where he has succeeded, therefore, based on the same, he cannot be punished. So, my lord, his punishment in the disciplinary proceeding was also set aside by the Supreme Court. Now, what I see what has fallen from your lordship is a point which perhaps needs some consideration. When we say prejudice, in what manner he is going to be prejudiced? There is an aspect perhaps it needs to be looked into.
Because once you see with the perspective of a criminal trial, then
But I was trying to visualize one more situation, my lord. Supposing X is the witness both in the disciplinary proceeding as in the criminal trial, then what happens?
the same thing, but still you see beyond case diary, APP can't proceed.
No, my lord, supposing it so happen, X is, cited as witness both in the criminal as well as the, disciplinary proceeding.
Here's a
Then-
case of sexual harassment to a student by a teacher.
No, what I'm saying is, my lord, in a given case, X is cited as a witness for the department in the disciplinary proceeding and for the prosecution in the criminal trial.
Yes,
My lord, he will give the same version.
you'll give the same version, but you see, if somebody is holding a brief in a criminal trial, I think he'll be most happy person if somebody goes beyond the statement made under 161 and he puts that question and the entire evidence goes.
There. My lord, I think the rationale
In a
is-
civil trial, I can understand the theory of prejudice because they have preponderance of evidence.
Yes.
Once that evidence comes,
Preponderance
then
of-
in a civil proceeding you can't go out. But in a criminal trial,
Perhaps, my lord, the Paul Anthony's only justification is end of the day, my lord, it is not only that justice should be done, it should be ensured that it is done. Therefore, to ensure that, my lord, there is a fair trial, no prejudice is caused. Therefore, my lord, as a measure, it was ordered that for the present disciplinary proceeding will not proceed. Beyond certain stage, that will may not come. Therefore, my lord, no, I mean, it all depends upon the facts of each case. No
Because in a-
general.
in a
That's why, my
different-
lord, in Kusheshwari Dubey's case, all these points are clearly explained. There's a judgment by the name Kusheshwar Dubey. I think their Supreme Court has dealt with everything. As such, there is no bar for simultaneously proceeding. Kusheshwar Dubey. 88 or something. Kusheshwar Dubey. There it said there is no bar, but Paul Anthony is the only exception. Even later judgments have also followed that line.
Yes, Paul Anthony has been followed consistently.
No, I quite see a point for what has fallen from your lordship, my lord. Maybe in an appropriate case, lordship may like to deal with the matter.
No, because this is only
No,
for academic
When we
interest.
say prejudice, what type of prejudice?
Yes, that is the only question. Since
I
I have the
follow.
benefit of both of you sitting here, I thought I should enrich myself. Thank you, Mr. Chaudhary.
Yes,
It's
deeply
only
honored.
for that clarification.
Yes.
But thank you for this, to Krishna Dubey. I'll
Yes.
read that.
My lord,
Yes,
my lord here has asked with regard to defense, my lord, may I submit one more thing? My lord, suppose, my lord is, while taking defense witness, my lord was speaking about the case diary. Defense witnesses are not there in case diary.
different, you
My lord-
you will bring a witness who goes against you.
My lord.
That is
No,
also
no, my lord.
surprising.
No, my lord, while giving DWs, my lord, DWs, for defense with my lord, DWs are, my lord, PWs are those named in the charge sheet, my lord, charge sheet. DWs are will be brought by the petitioner during the trial. And these DWs have to be brought in the departmental proceeding too, my lord. So in that, my lord, with only, my lord, a submission, my lord, with that.
No, I understand.
that aspect-
Let us assume that X is a defense witness.
My lord,
He's asked you a question whether A in the disciplinary proceeding has been convicted. Or what you call, he is punished.
my lord. No, my lord.
Let us say he says yes. How does it affect the trial?
My lord, DW may be a person who might have DW might have been a person,
No, no. What Mr. Chaudhary says, please try to understand that in correct perspective.
my lord.
You see, he said it in a very lucid words. You see that number one, in a criminal trial,
My lord.
it is evidence beyond reasonable doubt. And this is the proceeding in a disciplinary proceeding is only preponderance of evidence.
Probabilities.
So therefore, when there are two different parameters, you must know how to handle a criminal trial as a lawyer. What sort of evidence is there? What sort of evidence is coming? Let us say in a departmental proceeding,
My lord.
he says that yes, he has been punished. Just like Mr. Chaudhary said, he has been punished. But merely because of punishment in a departmental proceeding, can he be convicted in a criminal trial?
No, that cannot be.
No.
That cannot be. No, it's-
Okay. Yes.
My my lord,
My lord,
one last.
Just
submission.
yes.
My lord, one
Just
last.
a moment.
My lord, one last submissions. My lord, I may be wrong, just only on submission. My lord, I suppose the victim and the petitioner was accommodated together by a driver in the car to the place of occurrence, my lord. The driver might be a defense witness. And whole the case was upon with regard to the risk of life of the petitioner, my lord. Even I have made every amendment in this petition. Even when the order was passed for an interim and absolute bail before the Arunachal bench, he was garlanded with shoes and was moved before him. So here, so my lord, that defense witness may be moved at that witness, there may be a driver that might be brought before the DP proceedings. Since this is a case, my lord, with regard to risk of life, that has been stated every amendment over there, that person may be targeted while giving his defense witness before the criminal court. My lord, I'm just trying to place, my lord, with just, my lord, I may be wrong, my lord. So in certain aspects, my lord, defense witnesses, disclosure of defense witnesses might cause prejudice to the accused, my lord, sometimes in rare cases. My lord. In this case, my lord, the driver might be a person who has taken those two persons to the place of occurrence. That person has to be brought in the DP, my lord. He has to be brought to save the petitioner. He has to brought that person to the DP. Here the case was that this petitioner's life was targeted. So that person at that time may be given, but before a criminal court where there is protection of
That is
law.
only a wishful thinking. You see, number one,
my lord, I'm only
number one,
supporting this.
here the answer is very easy.
Hmm.
Number one, if you feel that witness may be intimidated in the criminal trial, you should have his evidence first. Why have you stayed the proceeding then? Criminal trial will proceed. He has given a statement against you. Now you want to bring him in the what you call the departmental proceeding. How will it help you?
Yes, my lord, because in criminal. yes,
You
my
are
lord.
saying that the
Yes.
witness may be threatened.
Yes, my lord, that
So
may
therefore,
be-
in a criminal trial, you have allowed him to be examined first. So by this, by staying this proceeding, you have caused injury to yourself.
That's this is now. My lord, with my lord, only my submission with regard to my
No, that
lord,
is okay, but you see, we are testing it.
because my lord, generally and my lord is absolutely
In
right. but
a criminal
general
trial,
cases-
the trial has taken place in Itanagar, wherever it is.
No, my lord, at Lokhimpur, we have five.
At Lakhimpur, okay. So Lakhimpur, the witnesses from Arunachal have come and
Yes.
deposed.
Yes, my lord. they have-
So definitely, what you call the evidence of driver.
No, my
assuming
lord,
that he's-
my lord,
No, it's okay.
yes.
We are just
I'll give an
proceeding.
example, my lord, in that.
No, it's okay. We are taking that example only.
Yeah.
If the driver has been examined, it's end of the matter. Now you can rectify
lord,
it in the
without-
proceeding.
Yes, my lord, my lord, without PWs, the DW means.
Let's see. Yes, Mr. Dev.
My lord,
And
University has given every opportunity to the petitioner, my lord. There is no prejudice was caused to him, my lord. Even there is no legal bar that simultaneous proceeding may not be held. In San Antonio case, my lord, Paul Anthony. My lord, standard of proof in the criminal proceeding and the department proceeding is quite different, my lord. Here is a preponderance of probability in a DP. And the criminal proceeding standard of proof is beyond reasonable doubt, my lord. And this also says, my lord, there is no bar for my lord simultaneous proceeding.
Where?
And my lord, paragraph 34, 35, and 36, then 1999 3 my lord.
Paragraph?
Paragraph 22 is also important, my lord. Then paragraph 35, the facts and evidence of both proceeding, namely the departmental proceeding and the criminal proceedings.
22 and 35.
Yes, my lord.
Okay.
In fact, in Saint Paul Anthony case, my lord, there is a ex parte departmental proceeding. Because of that, it was set aside and directed for fresh departmental proceeding. Para 34, it is written.
No, in this case, he was reinstated.
Yes, my lord, because of ex parte departmental proceeding, and lastly, it was directed for fresh departmental proceeding.
No, no,
We are not,
we would not direct fresh departmental inquiries. One thing is, he was not, he was reinstated with cost. He was directed to pay the entire salary. Last paragraph will indicate that.
and in that matter, my lord, the substantial allowance was not paid in Saint Anthony matter.
It's okay, those things are not material.
That's why prejudice was caused. Here, everything has been given to him. No prejudice was caused.
The defense, in your case, the defense witness is already over.
My
Already
lord,
over, my lord. Now,
in this stage of argument, my lord, on last occasion, because of this platinum jubilee celebrations, my lord, that is different, defense witness is over.
So we allow this, what do you call,
And
we allow
one,
the
my
department
lord,
proceeding to
one-
proceed now.
One more aspect, my lord, just my lord's knowledge. My lord, here, initially 3-member committee was constituted, my lord. And thereafter, they have discarded that they have submitted one-man committee. With that point also, challenges also made whether that person with inquiry officer was competent also. That point also has been raised because my lord, has page 15, my lord. I take your lordship to page 15, my lord. Page 15, the paragraph, because the one-man committee that has been constituted, my lord, he is at a lower grade scale of the petitioner, my lord. That stand is also been, my lord. Because my lord, I have not
You have the records of the disciplinary committee. Why one-man committee?
initially 3-man committee, thereafter 1-man committee, my lord.
One-man committee cannot take up departmental procedure, what do you call this, fact finding in a sexual harassment case.
no, first it was, my lord, 3-man committee was having.
Show me the records for that, why it was done, why it was a single-man committee. And why a person from a lower rank than the petitioner?
And with regard to the 3-man committee also, the status with regard to the 3-man committee persons were not disclosed to the petitioner. With regard to the 3-man committee, the state petitioners appeared before the 3-man committee twice. With regard to their rank and position was not disclosed to the petitioner. Thereafter, petitioner came to know that 1-man committee was constituted. And that person is lower in grade pay compared to the petitioner, my lord. My lord, page 82 NXRR. Page 82, my lord.
My lord, page 26 of my affidavit. my lord.
My lord, quoted page
Age?
82, my lord, NXRR.
That I have seen.
The first paragraph, my lord, this is the order, my lord. In which the committee was, 1-man person, committee was, my lord, 1-man inquiry committee was. Selected. Page 82.
You show me that it is permissible under your statute.
My lord, only result page 26 of my affidavit.
Yes,
The
I'm
the
reading that.
reason is minutes of
reading
the
that.
meeting, my lord, executive council of the. Annex of.
But then this action is not sustainable. The three-man committee gave a report.
Yes, it has already given an report.
After the report is given, on what basis the second committee was constituted?
After the report, my lord, when the three-man committee filed prima facie case against him, then
Can that be
Yeah.
done? You show me your
Yeah.
statute. Show me your statute. This can't be done.
And
And this is contrary to Vishaka. It says sexual harassment case, there should be a lady member.
Yes, my lord, that's why my lord, in three-man committee, there is a.
No, but three-man committee, you consign it to file. Then you made a one-man committee. Is it permissible? That's my question is.
My lord, in the issue of the rules of this university, it is not there, my lord.
Is there?
No, it is not there.
Then we set aside this.
The three-man committee will be there.
That has to be set aside.
No, my lord, one-man committee finding may be set aside by but the three-man committee,
Now, everything goes.
no, it was constituted subsequently, my lord, after the completion of departmental.
You see. It's a continuation of the proceeding. If the report goes, everything goes. You have already discarded the three-man committee. It can't stand. You did not act on that. You again constituted a committee to go afresh. Once you have discarded that, it can't survive. Sexual harassment of women in workplace.
my lord, I also take 85 and 86.
5 and 86.
85 and 86 page number. Immediately when it came to knowledge, I had submitted 85 and 86 a representation where I have,
85 are fragment.
my lord,
Okay.
85 and 86 that with regard to three-man committee, I was not provided. In the meantime, one-man committee was constituted. And I have even in 86 stated that this person is lower in rank to me and I have some appreciation. And this was even disregarded also. And the university has not considered my representation and has stated to be rejected, my lord. And even 88 also relevant, my lord, of the university letter.
Yes, Mr. Devi.
Yes, my lord,
What
yeah,
is-
what
under
is your
paragraph
statute say?
13, it is stated,
What does
In
the
my-
statute say?
My lord, 88 page, they are saying.
because this
here,
decision
88.
was taken by the executive council of the university, my lord.
No, that is okay. You show your statute.
My lord, at 88, I take your lordship, page 88, they have given their stand, my lord, with regard to one-man committee. When I raised an objection. Continuation
Paragraph
from
14, it
87.
was said, my lord, one-man committee was constituted because he should not be prejudiced, my lord, because of that. In para 14.
Para 14.
Yes. my lord. First, the executive council. Para 13, then paragraph 14. my lord. May I read, my lord? One man committee never will desire to expand the scope of inquiry. It is the duty of one man committee to inquire upon every aspect of the case. The allegation made by the petitioner against one man committee stating that one man inquiry committee belongings from the said committee is baseless and concluded. After perusal of one man inquiry report, there was no bias report which was prejudice to the petitioner. Petitioner could not beat out the integrity of one man committee which had an impeachable record in service area. As such, is the statement. Then paragraph 15.
No, then I'm sitting aside this inquiry completely. It is contrary to section 7 of the Sexual Harassment of Women at Workplace Act 2013. It says that the chairperson should be a woman.
Women in three-man committee, there is a woman.
No, but that you discarded. Conveniently, you discarded it. Once you discard it, you can't take the benefit of the same again. You conduct a fresh inquiry if you want now. It has to be under the act or no, there should not be any other way to do it.
Well, actually, it was not also discarded. The university find that no prejudice has been caused. That's why the another committee was constituted.
I understand.
Yes, madam.
From a full court, it goes to a single judge. We decided.
That's why the council has taken a decision. Executive Council of the university.
And that is okay. That is okay. Let them be happy with their decision. You can't help it. You save you if you want, you can save it by showing us the statute, which overrides section 7 of the Sexual Harassment Act.
Then, my lord, let me take instruction. But
No, not
as per
after,
the,
not after
that's
1
why,
hour.
my lord, this three-man
Not
committee.
after 1 hour of argument.
No, as per section 7, my lord, this three-man committee was constituted. There is a lady in three-man committee.
No, but they were found incompetent. That is why your executive council appointed a one-man committee who is lower in rank than the petitioner, drawing lesser pay band. You see, history repeats itself. There is a story which we read when we were young. It is a story of Akbar and Birbal, where when Birbal was thought to be punished by the king, he said that you choose your own what you call jury. And he said that, well, give me some common man as my juror. And so jury were very common man. And they also found the what you call, it would be taxing if they fine this man for more than 10 rupees. So even they deliberated days and days. If we find 10 rupees, how will Birbal live? And so ultimately a very small fine was given, 1 rupee or something. Because it's a common man, they can't impose a fine of 1 lakh rupees. We also say it here, there are certain high courts in the country and Supreme Court where huge fines are imposed on people. And in our court, we still think that 5,000 or 10,000 rupees as cost would be too prohibitive. So you have appointed a common man. It's okay, Mr. Deori, I'll
Yes,
sit aside. You can't stand. Heard. Mr. S.G. Barwar, on counsel for the petitioner.
only observation, my lord, there is no legal bar for press.
And Mr. S.K. Deori, learned counsel for the respondents. Next paragraph. the case of the petitioner is that while acting as a director of what is AITS?
My lord, it's Arunachal Institute of Tribal Studies, Arunachal Pradesh.
Okay. Arunachal Institute of Tribal Studies,
Arunachal.
comma. No, not comma, of Rajiv Gandhi University. Comma, he was accused of molestation and sexual harassment of female research work, female research student. And accordingly, the petitioner was put under suspension. And a show cause notice dated 10/10/2013 was issued for initiating the departmental proceeding against the petitioner. Full stop. On similar allegations, Itanagar Women PS case number 57 of 2013 was registered under section 354/342 of the IPC. Which was tried as GR case number 432 of 2013. Initially, in respect of the departmental proceeding, a 3-member inquiry committee was constituted. And as per documents placed in the writ petition, the inquiry committee, the 3-member inquiry committee had also submitted its report. First off, it is projected that thereafter, the executive council of the Rajiv Gandhi University by resolution taken in a meeting dated 19/3/2014. Decided to constitute a 1-man committee, inquiry committee. And accordingly, a 1-man committee was constituted of Mr. Raksa Pare KSCP, Yomcha YUMCHA, IPS, within bracket retired, to inquire into the allegations as per memorandum and articles of charges. In the meanwhile, in the departmental proceedings, charges were framed against the petitioner. And as parallel criminal trial was also going on, now the petitioner has approached this court by filing this writ petition under Article 226 of the Constitution of India, whereby the petitioner has prayed for declaring the departmental proceeding instituted consequent upon show cause notice dated 10/10/2013 to be illegal, improper, invalid, and void ab initio. And to set aside the departmental proceeding. Next paragraph. It has been submitted at the bar by the learned counsel for the petitioner. Upon a query of this court that in the criminal trial, the stage of defense witness is over and the case is now fixed for final argument. Next paragraph. Where is the article of charges?
My lord, at page 60, I think, yes, my
61.
lord, 60, continuation to 61.
60.
61 is the 60 and 61. 61, my lord, relevant.
The learned counsel for the petitioner has also questioned the constitution of an inquiry committee. And in this regard, the learned counsel for the respondents had submitted that this report has been given by the three-man committee.
Yes,
Yes,
my
ma'am.
lord, 87 and
Something like-
88, my lord, will be clear.
Report has been given.
87 and 88, page number of the read petition, my lord.
Which is submitted that the three-member committee in its finding had prima facie found the petitioner guilty of committing sexual harassment and molestation. Full stop. Nonetheless, the executive, by a decision of the 13th Executive Council of the Rajiv Gandhi University, bearing number capital EC colon 13 colon 12 Mr. Rakesh RAKESH Yomcha YUMCHA IPS within bracket retired, former DIGP, was appointed as a one-man inquiry committee to conduct an inquiry against the petitioner. It was submitted that after the commencement of the inquiry, the presenting officer had sent summons to the petitioner on 10/5/2014, 21/5/2014, 5/6/2014, 18/6/2014, by email and on 9/7/2014 by SMS in his mobile. And as the petitioner did not turn up and did not raise any question against the constitution of one-man inquiry committee before 5/7/2014, the objection dated 5/7/2014 raised by the petitioner was rejected, having been made after 2 months since constitution of the one-man inquiry committee on 1/5/2014. Next paragraph. It appears from the memorandum of charges served on the petitioner that the said memorandum was issued on 15/10/2013. Which was accompanied with the statement of articles of charges therefore, it is apparent that after service of memorandum of charges dated 15/10/2013 upon the petitioner, a three-man inquiry committee was constituted while order dated 30/4/2014. No, sorry, that will be 14. When was this committee constituted? 14/11/13.
14/11/13.
14/11/13. And that after the three-member inquiry committee submitted its report, the Executive Council of the Rajiv Gandhi University took a resolution in its 13th Executive Council meeting to appoint a one-man inquiry committee with effect from 1/5/2014. That three-member committee, the date was wrong. Earlier, I give some other date. It should be 18/10/2013. Page 87 says 18/10/2013.
It's not here.
No, this is his letter, my lord, but one more letter is there.
No, it is your own letter. Your letter says 18/10,
18.
third line, 18/10.
15/10.
There can't be any other date. Next question. The court finds that the composition of the local committee to make inquiry against the conduct of the petitioner is not in accordance with section 7 of the sexual harassment of women at workplace within bracket prevention, comma, prohibition and redressal bracket close act 2013. So the respondents has not been able to show from their acts and statutes that it was permissible to constitute a one-man inquiry committee after the 3-member inquiry committee submitted its report. So moreover, it has not been, the respondents have not been able to bring anything on record to show how the inquiry against the petitioner could be ordered twice. First, in the disciplinary proceeding, which has been initiated by service of office of memorandum dated 15/10/2013. And on the same set of allegation, how could a second inquiry regarding sexual harassment of women at workplace could be instituted? Which had been done after service of memorandum of charges by the order dated 15/10/2013. As indicated herein before, the 3-man inquiry committee was constituted by EC resolution dated 18/10/2013. By notification dated 18/10/2013 under number capital ET oblique PF -060 oblique MCB oblique 95 within bracket vol dash Roman 2 volume VOL dash Roman 2. This is page 87. And from NHF U to the writ petition, which is a letter dated 18/7/2014. It is admitted by the respondents that after the 3-member inquiry committee prima facie found the petitioner guilty of committing sexual harassment, a 1-man inquiry committee was ordered by resolution taken in the 13th Executive Council under number capital EC column 13 column 12. Followed by order dated 1/5/2014. Next paragraph, therefore, comma, it is apparent that the disciplinary proceeding was instituted earlier and the inquiry committee was constituted thereafter. Therefore, the petitioner has been able to demonstrate that he has suffered prejudice. As there is every likelihood that the inquiry which is ordered later in point of time would be referred to in the departmental proceedings initiated by the memorandum dated 15/10/2013. The petitioner has been able to demonstrate that he has suffered prejudice because the constitution of the local committee for inquiry is not constituted in accordance with section 7 of the full act, the Sexual Harassment of So and So Act, 2013. The respondents have not been able to show that they had constituted a local committee in terms of section 7 of the said act. And therefore, in this case, the inquiry is conducted by a committee specifically constituted for the case of the petitioner. Full stop. Next paragraph. One of the allegations of the petitioner is that the one-man inquiry committee constituted of a person who was drawing a scale of pay lower to that of the petitioner. So accordingly, the court finds that as the one-man committee is not constituted within the meaning of section 7 of the said 2013 Act, to have a one-man committee constituted of a person who draws lower scale of pay than the petitioner would definitely prejudice the petitioner. Next paragraph. Under such circumstances, the court is inclined to hold as follows. Number one, that as the criminal trial is at the stage of argument with the prosecution evidence and defense evidence being closed, there would be no, the petitioner would not suffer any prejudice if the department proceeding is not allowed to proceed. Number two, that the court is inclined to more beliefs by directing that in the department proceeding, which would now commence, would commence from the stage it has been stayed, the department proceeding will not be able to place reliance on the inquiry report by 3-member committee or by a 1-member committee, as the said committees were constituted after initiation of the departmental proceeding by memorandum dated 15/10/2013. Next level. Be that as it may, as there are allegations against the petitioner of sexual harassment of research scholar working under him, comma, if such an inquiry is still permissible under the provisions of sexual harassment of women at workplace, Prevention, Prohibition and Redress bracket Act 2013. The petitioners, the respondent shall be at liberty to inquire into the complaint in a manner as prescribed by law. Next one. It may be mentioned that the learned counsel for the petitioner has placed reliance on the case of petitioner as well as the learned counsel for the respondents has placed reliance on the case of Captain M. Paul Anthony TAUL ANTHONY versus Bharat Gold Mines Limited and another within bracket 1999, like it was 3 SCC 679. There is no necessity to discuss this said decision because in the meanwhile the defense, the stage of defense evidence of the criminal trial is already over, for which it has already been held that the petitioner would not suffer any prejudice. If the departmental proceeding is allowed to resume, the petition stands allowed to the extent as indicated above. There should be no orders to post.
Deeply obliged.
The departmental proceeding, a SOCOS notice is set aside, my lord, with regard to.
No, that will continue
That will-
because your the subsequent inquiry is out.
Oh, okay, my lord. Must oblige, my lord. Must oblige, my lord.
5 and 6.
Mr. Chaudhary is here, no? Okay, we'll take it up after some time then. No, because we had adjourned the matter for time being. We'll take it up after this matter is. Okay. Yes, Mr. Salia.
This application is directed against the non-consideration of the petitioner's candidature for the post of the first.
But Mrs. Haria,
Well-
just a preliminary question before you start your argument. You see, this 2011 Act is no longer there.
That's true.
So we'll have to delegate you to the director to take a decision because now it is this 2017 Act. We have to take a call under this, under the new Act. If you are eligible, then they'll adjudicate it. The issue of because the division bench of this court has already held that eligibility will be under the new Act, not under the old Act.
Yes.
That is what was
In
placed
that, in that case,
before
Lord,
me.
my submission will be that in the 16 case, 16 Act, 16 case. In a restriction of 16, 2016, 5209 of 16,
Yes,
petitioner challenged the order of provincialization of the respondent.
Yes. Because
So-
under the new act, you have the adjudicatory power by the director or by the tribunal. Correct. If you want, you can take instructions, we can take it up after some time.
No, your lordship can do one thing, since your lordship has stated that this order of provincialization will be set aside, since it was during the.
No, I'm not set aside, but we'll give him the director and authority to revisit this order of provincialization. Because if I set aside, it gives a message, different
No.
message.
No, it was set, it has to be set aside on a technical reason, because the case was pending. And under the act also, since if any case is pending, then during that position, my lord, during that period, one cannot, the director or department cannot provincialize the matter.
No, that is why we will make that mention in the order
My
and
lord.
say that he will revisit this order because of this this provision which you are referring to. Because if I displace any of you at this stage, it may cause serious prejudice when the director hears the matter afresh. So we'll tell him, we'll tell the authority to decide the matter, considering your claim, and take an independent view towards the provincialization order.
Yes,
Yes.
That of course, when if a lordship Miller holds Miller, the petitioner has got some Miller right. Miller. Otherwise, Miller, my case is.
No, you see, now it is 2017 Act.
My lord.
Whatever was projected was under the 2011
No,
Act.
because I was already provincialized, Miller.
No, that is okay.
Well.
But now the petitioner has challenged your appointment.
Yes, Miller.
Your provincialization was there under the 2000.
11.
11.
My lord.
Now you see to do an exercise of
Right.
finding the eligibility of you or vis-a-vis the petitioner.
My lord.
We can't give it to a logical conclusion. Because ultimately what happens is that now 2017 Act is there. The
Right.
parameters may be conducive or favorable to you, or it may be favorable to the petitioner, we don't know.
My lord.
But that exercise we can't do because this is under the 2011 Act.
No, my humble submission, if the lordship, suppose lordship allows the matter, that's a different issue. If the lordship dismisses the case, my lord, since I was already provincialized, my lord.
No, I'm not dismissing it. You see, I'm relegating the parties for adjudication before the director of elementary, sorry, this.
No, my lord, if after lordship hearing the matter, my lord, if lordship feels, my lord, that no, my lord, that the petition has no case, my lord, then my lordship will definitely not interfere with the my lord, order, perhaps, my lord. Otherwise, my lord, if lordship holds, my lord, that my appointment was wrong, my lord, then it's a different issue, my lord.
No, even if I hold that your appointment was right,
My lord.
but it was under the, you see, the 2011 Act then. But let us assume that you are validly holding that.
My lord.
But now he has made a challenge. The challenge is vis-a-vis 2011 Act.
That I know, my lord, but that will not obliterate the fact, my lord, that I was provincialized before this act was, my lord, set aside, my lord. So therefore, that provincialization order,
That will save you.
that will save me, my lord.
That is saved. But how do you educate the claim of Mr. Chalia then?
No, but if lordship holds, my lord, that Chalia, Mr. Senior's client has no claim, my lord, then it's the end of the matter. But if your lordship holds, my lord, that my appointment was wrong, my lord, then perhaps it's a different issue. Then, my lord, it's a question of whether, my lord, it will be under 2017 Act or 11 Act. Then the question will come. But if a lordship holds in my favor, my lord, there is no point of, my lord, adjudicating the claim of, my lord, my lord's client.
because one thing is there, as I stated, if the case is pending in the High Court, my lord, then that order could not have been passed. Only on that, my lord, I challenge that writ, my lord. Challenge that in the writ, my lord, in 16/5209.
Your initial declaration was this 117 or 2015.
Yes, my lord. During this pendency of the case, my lord, the provincialization has been made, my lord. My lord. Another matter is that, my lord, respondent number 9, my lord, earlier approached this honorable court, challenging my upgradation. And in that case, my lord, the honorable court directed to settle the matter by the district level redressal committee, my lord. And but the matter was not placed before the
Yes, okay,
redressal
we'll-
committee.
we'll- Mr. Chalia, just wait.
So that decision was challenged, and during that pendency, my lord, this order was passed. So that prohibition comes in, my lord. Provincialized could not have been done.
Okay, then you begin your case then. Mr. Chalia, just a moment. Mr. Chaudhary is here. Mr. Chaudhary, your,
Yes,
the party is available here?
My lord.
Yes, you're there. How much time it will take?
It will take some time, it's a matter pertaining to termination or discharge of a professional. They say, I say I am confirmed. So
Okay.
these two aspects.
Then
are
Mr. Chalia's matter, I think will take a shorter time. Then I complete.
My lord,
Mr.
finish it.
Is it such a long matter?
No, looking, Mr. Chaudhary, looking at the code, he will expand now. Yes, Mr. Chaudhary, you will begin with 11177 first.
My lord,
Yes.
my lord. My lord. This matter will be,
Yes, village. 1177, like 15. Your lordships, in this case, your lordships will find the inquiry report regarding the dual duty of the respondent number 8. Inquiry was conducted and
Just now.
yes, madam.
Respondent number 8.
Yes, madam.
Yes. Respondent number 8 and respondent number 9 in the second case are same. Right.
Madam, yes, same,
Same.
madam.
Same person. Okay.
Same, madam. The petitioner was appointed as the third assistant teacher in the school and respondent number 8 was appointed second assistant teacher. Thereafter, allegation was made against the respondent
Just a moment. Who is third?
petitioner, my lord.
Petitioner is third.
Yes, third. Petitioner is third. And respondent number 8 is second.
Yes.
Yes. Thereafter, allegation was made against the respondent number 8 that he had been performing dual duty in two institutions, at Anganwadi worker in Anganwadi center and the school itself. Thereafter, the inquiry was conducted by the DI of the school, and he found that he performed dual duties in two institutions, and there is a overlapping of the duty 2 hours 30 minutes, my lord. And
Yes.
yes, madam. Your lordship will find that inquiry report.
What is the name of the school?
School Balashi LP school.
How do I spell it?
Well, it is in the district of Dhubri, madam.
No, no. What is the spelling?
BALASI LP school.
Yes.
Yes. Your lordships will find page number 19, madam. Inquiry report, madam. Inquiry report. Mallet in middle mallet. In this inquiry report, it is held that she had been serving in two institutions. Mallet. Two institutions, one is Anganwadi center and school itself. Mallet. And she performed came to the school overlapping the 2 hours 30 minutes. And the school schedule is up to 12 AM. Your lordship will find page number 20, middle portion. In this regard, it is also mentioned that as per the departmental schedule, the Anganwadi worker 8 AM to 12 PM and schedule of working hour of the school 10 to 33 PM. The gap of 2 hours 30 seconds, madam. This is the overlapping duty, madam. Thereafter, your lordships will find
Yes.
thereafter a said report was submitted before the DO, madam. DO, madam, and thereafter the additional deputy commissioner education directed to the DO, madam, to take necessary action against the respondent number 8 as per the inquiry report that is earlier, madam. Your lordship will find that annexure, madam, page 21, madam. additional deputy commissioner education. This is the letter of the additional deputy commissioner education to the DO to take necessary action as per the inquiry report. My lord.
Yes,
Thereafter, my lord, DO itself passed the order, my lord, that is page 23, my lord. My lord, in this order, DO held the view of the earlier inquiry of the DI, my lord, and moreover, it is held that the school is the bencher, so managing committee has the power to upgrade, degrade to the teachers. So managing committee will take the decision in this matter, my lord. So, my lord, your lordships, thereafter, the managing committee and letter was issued to the president of the SMC of the city school to take necessary action. Your lordships will find page number 25. My lord. At that time, that school was controlled by the my lord, controlled by the Assam Non-Government Education Institution and Regulation Act 2006. Managing committee has the power over the appointment and upgradation of the teachers. So that was referred to the managing committee. Thereafter, managing committee, headmaster of the school, issued show cause notice to the set respondent number 8, alleging that he had been serving in 2 institutions and overlapping the duty in the school. And thereafter, the respondent number 8 also filed the show cause reply. In the show cause reply, she admitted that she had been performing in 2 institutions and overlapping the duty. And moreover, she said that there is no time schedule in the Anganwadi worker, so there is no overlapping. And moreover, he admitted that he took the remuneration and benefit of the 2 institutions, benefit of the 2 institutions, financial assistance from the school and the remuneration from the Anganwadi center. She admitted. Thereafter, not being satisfied his reply, the managing committee, by the majority member, degraded the respondent number 8 to 3rd post and promoted to the petitioner to the 2nd post. That was challenged before this honorable lordship, before the honorable court. That is your lordship will find page number, my lord. Page number 40, my lord. Order of that case, my lord.
40.
40, my lord. 40, my lord. 6.
Where is the order of degradation?
My lord.
Where is the order of degradation?
Degradation, yes, my lord. That it is the yes, my lord. Your lordships will find page 33, my lord. This is the resolution of the managing committee, my lord. Page 33, my lord. Next one 9. Middle person, my lord.
Yes.
Thereafter, the respondent number 8 approached this honorable court, and honorable court passed an order that is page start from 39 and 11% page 40. Bottom portion. In the view of above, the writ petition is disposed for providing that the DO Dhubri shall refer the matter to the district level redressal committee towards resolve the dispute as has been raised in the writ petition. Let the dispute be resolved expeditiously as possible. Needless to say that impugned order resolution dated so and so.
We are reading where?
Page number 40. Page
40.
number 40. 40. Here is the clear direction to the district level redressal committee. District level redressal committee and district level scrutiny committee is a separate committee. They have taken the decision in violation of this honorable court. And her post has been provincialized as per the resolution of district level redressal committee, not district level scrutiny committee, not by the decision of the district level redressal committee. Thereafter, my lord, one post already been filled up by the department and one post kept vacant.
No, show me the order which was passed subsequent to 12/12/2013. Subsequent to page 40, what has happened?
My lord.
Subsequent to page 40, what had happened?
After page 40, my lord.
Yes.
Thereafter, my lord, one post of the school has been provincialized and one post kept vacant. My lord. Thereafter, my lord, the DEO not placing the matter before the district level redressal committee, that matter was referred to the director for clarification. My lord. Director said that post of the respondent number 8 cannot be provincialized because she had been serving in 2 institutions, and post of the petitioner cannot be provincialized because his post has been promoted after 2011. But that is wrong, wrong. 2011. There is no bar. But your lordships will find that communication, page number 46. This is the director communication. The post of the respondent number 8 cannot be provincialized.
Yes.
Thereafter, my lord, the impugned order in the next case, my lord, impugned order was passed. Your lordships kindly take the next case, my lord, then impugned order. My lord. Next case, my lord. Case number 62, my lord. Next case. Item number 5. And during that pendency of that case, my lord, and without the violation of the High Court's order, that was directed to decide the matter by the district level redressal committee. There is a district level redressal committee that was not decided by the district level redressal committee. That was decided by the district level scrutiny committee. That is a separate committee. And during the pendency of the writ petition, earlier writ petition 1117715, and there is issued notice was issued, and party that particular respondent was made party. Notice was issued. During that pendency of the writ petition, my lord, this impugned order was passed, and here in the impugned order cited a WBC, my lord, that is the WBC number 2013, whereby directed to resolve the dispute by the district level redressal committee. Here in the order cited that matter was decided by the district level scrutiny committee, my lord. And your lordships will find their affidavit, my lord. That affidavit of the respondent number, my lord, 8, my lord. In and the next case, my lord. For the impugned order was challenged, their affidavit, and their affidavit here annexed 2 documents, who is demonstrated that matter was decided by the district level scrutiny committee. Affidavit, my lord. Affidavit by the respondent number,
What is the
Just-
prayer in the first petition?
my lord.
What is the prayer in the first writ petition?
Yes, first rate petition, my lord. 11715.
Yes.
Kindly see their affidavit, my lord. Respondent number 9, my lord. In case number 520916.
Yes.
Case number 8, my lord. Annexure C, my lord. Here clearly stated that the matter was decided by the district level scrutiny committee. That's why the district level scrutiny committee recommended the name of the respondent number name 8 for provincialization. That minutes your lordship will find page number 19. The minutes. That is the minutes of the district level scrutiny committee, not by the district level redressal. District level redressal committee has to pass first order. Thereafter, district level scrutiny committee has to recommend it, because there is a direction of the Honorable High Court. Without violating that order, Honorable High Court, they cannot pass the order, my lord. They can take the decision, my lord. Since there is a order, my lord, particularly a specific order, my lord, and that order was passed as per the advice of the departmental advocate, my lord. They said that there is a redressal committee. Redressal committee will resolve the matter. And during the pendency, my lord, during the pendency of the earlier case, my lord, the impugned order are very interestingly, my lord. Your lordship, you kindly see the impugned order itself.
What is the constitution of the redressal committee and the scrutiny
Yes, my
committee?
lord. Yes, my lord. Redressal committee, my lord. This is the act, my lord. Your lordships will find the act. Two 2011 act, my lord.
Give me the page number.
Page number, my lord. 658. 658, my lord. Section 10, my lord. District level redressal. This is the district level redressal committee and
658. Yes.
658. district level scrutiny committee, my lord. Your lordships will file next page, my lord. 659, district scrutiny committee. District scrutiny committee, district scrutiny for elementary. Last, my lord, in page number 659, bottom portion, my lord. Point 8, my lord, district scrutiny committee for elementary education shall be constituted with the following members, namely 659 page. As per the Act 2011, my lord.
Yes,
Yes, ma'am. My lord, Deputy Commissioner, District Elementary Education Officer, and Deputy Inspector of Schools, Block Elementary Education, one eminent person in the field of the education to be nominated by the Deputy Commissioner. This is the district level scrutiny committee. And I have, my lord, submitted the district level redressal committee, my lord. There is a separate committee, my lord. Middle person, my lord. And identity is separate, my lord. Although some members is same, my lord, but identity is separate, my lord. Oh, it will. Oh. My lord, kindly have a look. My lord, kindly have a look again in the input order. In
no, but
case
you
number,
see, this would not help you. If you're showing me this notification, it will not help you. You see, this, because this is a notification of 20 February 2014.
Hmm.
The High Court order is of 11/12/2013. So when order is passed in 2013, I would not be referring to a 2014 notification.
my lord, your lordship, see the order of the High Court, my lord. Order of the
No.
High Court.
You see, I have seen
There
the
is
order.
a specific direction, my lord.
I understand, but if that committee
But
itself did
that
not
may be another
exist,
committee, my lord. That may be another committee. That committee is not in my hand, my lord. That may be another committee. Department, no, my lord. Department, no, my lord. That may be another committee. Then, and this observation was made by the, as per the submission of the departmental advocate, my lord. My lord, kindly see the order.
yes.
My lord, moreover, my lord,
This is committee then, 2013.
As per 11 Act.
Please come to this side.
I can see it is modified.
yes, maybe.
At the top of your work, you will see, in continuation of this office. Notification dated 13, the composition of the state level committee. And terms of reference and the district level committee has been modified,
Oh, yes.
Yes.
Earlier it was there.
My lord.
There is a scrutiny committee, my lord, as per the old act, my lord. Section 10, my lord.
No, but look at this, Mr. Sadia is right.
Yes,
There is a earlier notification.
My lord,
earlier was.
one
modified.
submission, my lord.
In 14.
My lord, in the input order, in the provincial order, your lordships see the point 4, my lord. Your lordships will find page number 62. in the present case, my lord. In 6209. Case number 62, my lord. Point number 4, in the provincialized order, my lord. No provincialized order will be affected in point four, my lord. No provincialized order will be affected in case of schools having any court case in connection with appointment of teaching dispute on land, absence of dice court, so and so. My lord, this order in the impugned order itself stated, if any case is pending regarding this appointment, no appointment order will be executed. My lord, in this case, my lord, my earlier reputation is pending. My lord. It is admitted, my lord. Earlier reputation is pending. And director knows that case is pending because notice was issued. That's why the column number 4 has been inserted here. And my lord, I have relied on 2 judgment, my lord.
No, just a moment. I'm just asking you about the 2013. I'll come to you. Yes.
My lord, moreover, I am relying 2 judgments of this Honorable High Court, my lord, regarding the when the court is in session in a matter, the administrative authority cannot pass any order. And there is a guideline of the Department of Justice, my lord. That guideline also, my lord, online I have collected online. There is a point when the matter is under sub judice, the administrative authority cannot pass any order. That is the guideline of the Department of Justice, my lord, Indian government. My lord. Point number 4, my lord. The online mandate I have collected from all. No administrative action can be taken on a grievance, subject matter of which is sub judice. Point number 4, my lord.
No, this won't help you. Department of Justice won't help you unless you show that the Department of Justice guidance has been accepted by the government of Assam. Department of Justice is a central government.
Yes, sir. Yes, central government.
So unless the state government accepts it, it will not be binding.
Let High Court judgment is there, my lord. I have referred, my lord. High Court judgment is there. My lord. Yes. my lord. Yes. 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 2 judgments I have referred, my lord. And one of the division bench or the sample bench. In short, my submission is that, my lord, she was degraded. Petitioner was promoted. He was degraded because she performed dual institution simultaneously, and that is not permissible in law. And she overlapped the times 2 hours 30 minutes. Thereafter, my lord,
No,
the-
that is okay, but please tell
But-
me. In one writ petition, there is an order to have a matter scrutinized by a district redressal committee, correct?
yes,
After this redressal committee doesn't pass an order, it is to be part by the director. Correct?
yes, my lord.
So you see. For the time being, we are not on that issue of redressal forum or the scrutiny committee. But once there is a direction of the High Court
Yes.
to do a particular exercise and the director has done it. If your writ petition is pending, it is your duty to ask for a stay of that what you call exercise. Unless you do it, the order of the court has to be complied with. Can the performance of an order of the court be stayed just because there is a writ petition pending?
My lord, after passing the High Court's order, my lord, the petitioner filed RTI petition, my lord. What has they are doing, my lord, in this regard? No information has been given, my lord. No information has been.
No, that is okay. If you
Moreover,
don't-
my lord,
if you don't have
moreover,
information,
after provincialization, appeal was filed, my lord. Appeal petitioner has preferred the appeal against that order, my lord. And in the case, my lord, earlier case, my lord, director himself stated that post of the respondent number 8 cannot be provincialized. And same director provincialized his post. And in the order, my lord, initial stage, my lord, additional deputy commissioner, who is the chairman of the district level scrutiny committee, she directed the managing committee to take the necessary action against the respondent number 8, my lord. And again, she, being a chairman of the district level scrutiny committee, adopted the resolution in favor of the respondent number 8, my lord. What is this, my lord? Why twist, my lord? Same officer, why twist, my lord?
okay, Mrs. Alia, you have anything more to add?
My lord, nothing, my lord. One, my lord, my senior.
Since in the order itself, it states, Milan, page 62 also has seen that no provision can be done. So that says, Milan, it has to be suspended. So as your lordship has initially suggested that the matter can go back to be decided on 17 under the 17 Act, Milan. During that period, it will be suspended since it has not been affected till this time. And there is a specific direction also in column 4 of the order itself of provincialization. So in view of that, suspending this order, Milan, your lordship will refer the matter to the department to consider the whole thing afresh under the new act.
Moreover, one thing, my lord. In persons of the High Court's stay order, in the next case, my lord, the department director has passed the order staying his appointment. In
Mr.
case,
Did you
in
stay
case
here?
of 5029, stay order is here, my lord. Justice
That was stayed.
will be stayed, and that appointment is stayed. And on persons of the interim order, had the appointment of the respondent number 8 stayed, director has passed the order, until and unless further order of the High Court, his appointment is stayed. So,
Where is that?
my lord,
The order by Senate Cabinet. Here's my submission.
Where is that order?
Again, huh?
Yes.
Here, my lord, in the order of the provincialization, in column number 4, it is specifically recorded that no provincialization order will be effected. Well, that means, my lord, the provincialization of the private respondent has not effect to that effect till that month. And further, my lord, the old act has already gone, my lord. Now, my lord, director has to decide it whether, my lord, which one is eligible for appointment, my lord, as per the new act, my lord. So, my lord, let the director take a call, my lord.
Lanesh Friend's submission is contrary to the what is in affidavit in time. But here, my lord, that's technical, two issues have been raised, my lord. One, of course, with regard to my, whether I'm entitled to be provincialized, with regard to my qualification, that I was holding two posts. That is the one of the primary issue, my lord, with regard to the merit of the case, my lord. The others are technical issues, whether, my lord, I could have been provincialized during the pendency of the case, my lord. Whether, my lord, the district scrutiny committee and the state, district level scrutiny committee, the redressal committee are different bodies, my lord. Whether they were overlapping the powers or there were separate powers, these are, my lord, technical issues that have been raised, my lord. With regard to, I'll, my lord, first address the submission made by my learned friend, my lord, that the petitioner working in two, my lord, establishments. One, my lord, as an Anganwadi worker, my lord, and another as, my lord, as an assistant teacher. What had happened, my lord, these are venture institutions, my lord. Now, as an Anganwadi worker, my lord, it was what has happened, the Anganwadi center was, my lord, operating from the same school. Now, for that purpose, there was no timing fixed, my lord. My lord, in fact, I'll show from the in NX notifications, my lord, with regard to Anganwadi centers serving in the same campus, my lord, there is no fixed timing. So what she was basically doing, my lord, she was serving as an honorary teacher. And my lord, in the morning, my lord, she used to perform her duties as an Anganwadi worker, my lord. And my lord, the appointment as a, my lord, teacher is an honorary, my lord. And when, my lord, this my lord, regularized, my lord, this Anganwadi, my lord, regularization took place, my lord, thereafter she immediately resigned. So when, my lord, she started receiving financial, my lord, when the question of receiving financial benefits came, my lord, she resigned from the post of Anganwadi works, helper, my lord. That resignation came, my lord, in the month of May 2011, my lord. It was, my lord, decided that remunerations will be paid, my lord, and in the month of June, my lord, she immediately resigned when this notification things came about, my lord. So therefore, my lord, and my lord, with regard to timing of the school, my lord, this is a, my lord, totally wrong information, my lord, that was, my lord, given, my lord, that the timings are clashing, my lord. There was only one notification, my lord, which came, my lord, 26/5/2011, my lord. In that notification, my lord, only timings were fixed, my lord, where the Anganwadi centers were having permanent buildings. Their, my lord, timing was fixed, my lord. And that notification came only in 26/5/2011. And, my lord, she resigned as Anganwadi helper, my lord.
Where is that notification?
Yes, my lord. Because, my lord, we made an inquiry, my lord, as to what is the timing, my lord. Lordship will finally first kindly takes page 7, my lord, where this is my resignation letter, my lord.
Which petition?
My lord, my 520916, my lord. Affidavit by the respondent number 9, my lord. Annexure A, page 7, my lord. On, my lord, 27, my lord, 6, my lord, she resigned, 11/2011. And, my lord, on 28/6, the next day, the resignation was accepted, my lord. So, my lord, she resigned as a child, my lord, Anganwadi helper, my lord. Then lordship will find annexure B. I submitted an RTI application, my lord, asking for, my lord, a timetable, my lord, of the Anganwadi, my lord, workers, my lord, and helpers, my lord. My lord, what the Child Development Project Officer, my lord, Golakganj, Dhubri said, that any notification order regarding scheduled timetable for working hours had not been received by the higher authority, from the higher authority, during 2002 to June 2011. So, my lord, from June 2002, my lord, to 2011, June 2011, my lord, there was no, my lord, timing fixed for the Anganwadi, my lord, the centers, my lord. So you are requested to communicate directly with the higher authority for notification order regarding timetable of working AWS.
What is the job of Anganwadi worker?
Anganwadi help. She was a helper, my lord.
Helper?
My lord. Basically, my lord, morning, my lord, they have to. They, my lord, it's kind of, my lord, they provide meals and all, my lord. In the morning, my lord, the school students come to the school, my lord, the children come to
So
the school.
if there is no time fixed, I have to give what you call send my child for midday meal. She may come at 12 o'clock in the night.
No, well, what has happened with that's what, you know, here, in June 2011, therefore, my lord, the timing was fixed, my lord.
No,
It was not there, my
I'm
lord.
just trying to understand.
My lord,
Supposing I have to feed my child in the Anganwadi center,
my lord,
I may have to wait till 10 o'clock also in the 12 o'clock in the night also.
my lord. My lord. Well, that normally, my lord, what happens, my
No,
lord?
no, I'm just thinking aloud.
Yes, my
If
lord. The lordship right,
there is-
that lordship
there
is
is
right.
no time.
But my lord, generally, my lord, my lord, morning hours, my lord, the children gather, my lord, and they, my lord, do some service, my lord. Well, of course, my lord, I have to, my lord, I'm not very exactly what duties I perform, I have to, my lord, get some instruction. And my lord, they told my lord, some my lord, extracurricular activities, my lord, they are taught, my lord. It's basically, my lord, related, my lord. Then, my lord, lordship will
But
find,
Mr. Datta,
my lord.
you see, in the RTI applications,
Hmm.
it is the art of asking questions which will elicit reply.
Yes, my lord. That is
You don't ask a question in your center, what is the time?
my lord. No, my lord, then, my lord, 26, my lord, 26, my lord, May, my lord, 2011, next page, my lord, page
No,
10.
that's okay. But your RTI query is not here.
That is not here, my lord. But,
You
well,
said any notification order regarding scheduled timetable for working hours
Has not been
has not been received.
my lord.
So if your question is whether you have received
Yes,
any so and
Of course,
so,
my lord. Of course.
he will say no.
Of course, my
But
lord.
you don't ask the question,
Of course, my lord.
what is the timing of your Anganwadi center?
Lordship is right. But then the department
She
said,
is
my lord,
attending
till
all
2000,
these years. She has been attending all these years.
till 2011,
No,
my
that
lord,
is
there was-
okay. You see,
And
since
Your Lordship, under the Assam Services Conduct Rules, Milord, 1965. Rule 12,
he can't have
it
second
is not
employment.
permissible.
He can't have second employment without
Yes.
permission.
No second employment.
No, well, this is a venture institution, my lord. So therefore, personal venture institution, my lord. And my lord, this was, my lord, from the same campus, my lord. The Anganwadi school, my lord, and the center was situated in the same campus, my lord. So there could not have been overlapping, my lord, in any case. Once one is over, my lord, the others is to start, my lord. And it's all related, my lord. This institutions, my lord, are, my lord, catering to education needs, my lord, of these poor people, my lord, the villages, my lord, on their own, my lord. And therefore, my lord, and this is an honorary job, my lord. So therefore, that will be a position where, my lord, if the person is a government appointed servant, my lord, then, my lord, she can definitely cannot take up 2 jobs, my lord. Here, my lord, both of these jobs are honorary, my lord, without any remuneration. And now, the moment, my lord, remuneration issue started, my lord, in financial, my lord, with regard to Anganwadi workers, my lord, she resigned from the post, my lord.
Okay.
Now, my lordship will see, my lord, in May 2011, the notification which is there, my lord, it says, my lord, this is the general information all concerned. The timings of Anganwadi centers with permanent buildings and Anganwadi centers in club building premises under ICDS schemes in the state government as per the guidance of Government of India have been fixed to be shown for maintaining the uniformity in the time schedule of day activities as well as periodic activities by the Anganwadi centers with immediate effect. So, my lord, this is where, my lord, the timings have come, my lord. 8 AM to 8:30 AM morning prayer. My lord, welcome, checking of personal hygiene, serving morning snacks. Then 8 to 10, my lord, 10:30. No formal pre-education, preschool education. And 10 to 11, treatment of common childhood illness, ailment and referral, preparation of supplementary nutrition. Lordship will see, my lord, one of the part is, my lord, pre-formal education, my lord, school education. So therefore, my lord, what I'm trying to say, my lord, these 2 jobs, my lord, even if they're separate, my lord, the basic, my lord, idea is also, my lord, in the Anganwadi helpers or Anganwadi system, my lord, is to, my lord, administer some, my lord, pre-formal school education, my lord. So therefore, the duties, in my humble submission, my lord, first, my lord, we have made a categorical statement. We are serving the morning, my lord, in the Anganwadi center, my lord. And thereafter, in the, my lord, from the school started, my lord, I used to serve in the school, my lord. And these being honorary jobs, my lord, it cannot be, my lord, put at par, my lord, any other government job, my lord, where I am not, my lord, debarred from, my lord, taking up any other appointment, my lord. So that is one, my lord. Secondly, my lord, so far as the district scrutiny, my lord, decision is concerned, my lord, lordship will find, my lord, under the act,
Yes.
Under the Act, my lord, only this, only district scrutiny committee is provided, my lord. The Act doesn't make in distinction, section 10, my lord, which
But nobody in its wisdom, none of the respondents in this writ petition,
my lord,
what is that is 361 of 2013
my lord.
approves this court for modification of the order.
No, no one, yes. That's not. But my submission is, my lord. There is nothing to show, my lord, that this, my lord, under the Act only there is one committee, my lord. And my
But
lord,
the committee exists. Mr. Sadi has been able to.
yes,
show-
my lord, it's notification, my lord. But then, my lord, can it override the Act, my lord? That will be one of the questions, my lord. Because, my lord, the scrutiny committee is under the Act, my lord.
No,
not
but
on the
when you
notification.
see, it's-
And my lord, whether,
You know the meaning of word fait accompli.
my lord,
Once the High Court passes an order
my lord.
and you don't object to it, it is fait accompli.
That's right, my lord. But lordship will see, my lord, whether, my lord, this committee, my lord, whether this the constitution of the committee, my lord, and my lord, whether the committee exactly, my lord, what was the whether the committee was exactly functioning, my lord. Because, my lord, under the Act, the my lord, my lord, the district level scrutiny committee was, my lord, the justice scrutiny committee is, my lord, what has been envisaged, my lord. And there is no other committee, my lord, delegated any power, my lord.
No, you see, we can't do anything about it. Page 40 says that the Standing Council for the Education has produced a notification dated 30/3/1/2013.
My lord.
So once it is there, this court went ahead. Now we can't.
Well, they have not, of course,
Nothing.
say they have not, it is not also their stand, my lord, that these two committees are different, my lord. The nomenclature may be different, my lord, but then, my lord, it might have been, my lord, just used as a, my lord, as a district level scrutiny committee, my lord, or my district level redressal committee, my lord, instead of the word scrutiny, my
Nobody
lord.
is producing anything before us. So we have to ask the director to examine.
Because, my lord, of course, my lord, notification, can I have the notification?
No, it does not have that notification. This is what Mr. Sadia is showing us is that the notification of 30 January exists.
13th January. So fine, my lord, 13th January, I'm not disputing that, my lord, when my lord is senior, because that is also referred, my lord, in the order also, my lord. I'm not disputing that, my lord, but then they should be, my lord, if the committees are similar, my lord, if the person, my lord, the same committee, my lord, with same kind of personnel, my lord, then, my lord, these two committees are no different at all, my lord. My lord, it might just, my lord, the district scrutiny committee might, my lord, the word
No, but
district.
you see,
might
Mr.
be used, my lord.
Mehta, I cannot add or subtract words which are used in the order dated 12/12/2013.
I understand, my lord, I understand, my lord. So let them, my lord, let them come and clarify, my lord, that whether these two committees are different committees, my lord.
No, why should we keep it pending? It's the 2013 matter. Sorry, the 2000, what do you call it? Dispute is of 2012.
Well,
Yes.
So
11
was-
years, why should we keep it pending?
that is true, my lord, that is true. Well, but perhaps they can get the instruction at 2 PM, my lord. Well, perhaps they can get the instruction, my lord, if it's possible, but I don't know, my lord, if it's possible to them, my lord. It's a verbal instruction that is required, whether these are two different committees, my lord.
Try to get it.
My lord,
Because it-
I'll make the other submissions, my lord. My lord, so far as, my lord, the other aspect is concerned, my lord, whether a person can be degraded, my lord. That, my lord, my submission was, my lord, that was without, my lord, hearing me, first of all, my lord. No opportunity of hearing was given, my lord. Secondly, my lord, I join on a particular day in a school, my lord. Can it be said that no, I become junior to someone? Because, and my lord, lordship will see the order which was passed, my lord, degrading me, that was on the basis of, my lord, some order of some former president. Very interesting order, my lord. That is not, my lord, a finding of the committee, my lord. My learned friend has referred to this order at page 33, annexure 9 of his writ petition, my lord. 1177/2015. Lordship will see how this order has been passed, my lord.
Page.
Page 33, annexure 9 of WPC number 1177, my lord. Resolution 1. Just because, my lord, the former president, according to the last resolution, so and so, since the majority expressed their opinion to promote Ismail Ali Sheikh, therefore it is decided to promote him as a second assistant teacher as per letter dated so and so of the former president. So, my lord, they bring in all extraneous materials, my lord, from letters from former president to, my lord, decide this issue, my lord. They don't give me a hearing, my lord. I have made a specific statement in my affidavit, my lord, that they have not given me opportunity of hearing, my lord. And, my lord, I join on a particular date. He joins on a particular date, my lord. Can it be altered, my lord, by a committee? Because some committee members feel, my lord, that this should be altered, my lord. Degradation and upgradation, my lord, cannot happen just like that, my lord. Well, if I've done something wrong, you can remove me from the school. That's another issue. But you cannot degrade me, my lord. You cannot change my date of joining, my lord, from my lord, previous date to a later date, my lord. That is simply which cannot be done, my lord. So therefore, my lord, the entire issue, my lord, in fact, the district scrutiny committee, my lord, in my affidavit, page 19, has referred to the headmaster was misleading the committee, my lord. Page 19 of my affidavit, my lord. Well, this order refers to this district scrutiny committee refers to some order of the DE, District Elementary Education Officer, Director of Elementary Education Assam, by memo dated 9th March 2016 in relation to WPC number 361/2013, dated 12/12/2013. As per Honorable High Court's order, the district elementary education officer apprised the matter of Saleha Khatun, who is the first assistant teacher of Balasi VLP school. The DSC also examined a statement of the petitioner in the response number 678, recorded the timing of the hearing held on so-and-so in compliance with the Honorable High Court's above order. The DSC also perused and examined other relevant records and documents of Balashi at VLP school. The matter under examination was relating to wrong upgradation of the respondent number 8, Ismail Hussain, third assistant teacher, to the post of second assistant teacher in place of Saleha Khatun by resolution of the school managing committee dated 22/11/2022. It is seen from the records that the head teacher of the school has misled the SMC as well as the department and has made disputed the matter of the petitioner. But the petitioner, Srimati Saleha Khatun, is serving in the school till date. As per school records and the statement of the petitioner in response number 6, 7, and 8, it is seen that Saleha Khatun is the first assistant teacher of Balasi LP school, and the DLC Dhubri already proposed her name for provincialization of services under the Assam Venture Education Provincialization of Services Act 2011, as amended in 2012. Hence, the DLC resolved to propose the name of Saleha Khatun as assistant teacher, Balasi VLP school for provincialization under the above mentioned Act 2011. The DSC Dhubri requested the DEO member secretary to submit a proposal as per the Honorable High Court's order dated 12/2013 in WPC number so-and-so and the DE Assam above letter to the higher authority. So, my lord, the DE's letter, my lord, by which, my lord, this case was referred. This is also very relevant, my lord. What, my lord, because pursuant to the order of this honorable court, my lord, the director of elementary education referred this matter, my lord. That, my lord, only the department perhaps could have produced, my lord.
The properly not produced because of the fact that the authorities of that what you call the scrutiny committee,
My lord.
deputy commissioner gives recommendations of some other effect. And then changes his stand and says that you be recommended.
And under the 2011 Act, my lord, seniority is on the criteria. Of course, in 2017 Act, that is not there. I was appointed in the school, my lord, on 10/10/1991, and she was appointed in 1997, my lord. He was appointed in 1997, my lord. So by this particular, my lord, decision of the managing committee, my lord, I could not have been, my lord, made junior to the, my lord, petitioner, my lord. And, my lord, in my affidavit, I have made a specific amendments, my lord, that from the Anganwadi center, I was receiving lump sum amount, my lord, and for the school, I received nothing. And when school started receiving financial assistance in May, my lord, I resigned from the, my lord, post of Anganwadi helper, my lord.
You should try to get me that 2013.
Here, distribute this facts, kindly see, page 29 of repetition number 5209. Report of the district elementary education. Report of the district elementary education. 5209.
Yes.
Well, here, this district elementary education officer has given this report, kindly see the report of
Page.
repetition number 5209, 2016, page 29, annex 5, The report of DIF schools, Dhuburi, hide his letter number so and so dated 10/7/2012 and report submitted by the BEO, Agomoni, hide letter number so and so dated 23/2012 findings. It appears from the report dated 10/7/2012, the DIF school Dhuburi, that Balasi VLP school was established in the year 1985 under BEO Agomoni. Muhammad Ali was appointed on 3/2/1985 as head teacher. Saleha Khatun was appointed as assistant teacher on 10/3/91. And Sri Ismail Ali Sheikh was appointed on second assistant teacher on 10/3/1997. It also appears from the report of the DIF school Dhuburi that Srimati Saleha Khatun was also appointed as Anganwadi helper at 71 number Balasi LP school, and she worked in the said Anganwadi center with effect from February 2002 to 26/6/2011. Thereafter, she submitted her resignation from the Anganwadi helper on 27/6/2011. During this period, she performed her duties in 2 institutions simultaneously, whereas the working hours of the school is 10 to 3 p.m. and Anganwadi workers Anganwadi center from 8 a.m. to 12:30, which is not permissible as per government rules. It also appears from that report that she took remuneration from the Anganwadi center and also received FF from the school. Here 2 reports. Kindly see, one district elementary education officer has given this report in the year 2012.
Mr. Bola, that argument would not stand for 2 reasons. Number one, Anganwadi, this court has held that Anganwadi helper is not a civil post. So if the conduct rules do not apply for Anganwadi helper, definitely in a venture school, a teacher in a venture school would not be covered by government notification.
What I am submitting, let the director decide regarding this issue after hearing the parties. Also, all act is not in force right now.
The director has filed his affidavit, What my learned friend is submitting is not from the affidavit. Director has said whether the district scrutiny committee had been not recommended my case, and I was appointed, The director is not disputing anything,
The only point is constitution of that redressal committee,
I'll bring the
2013. Only that much.
And finally, the district scrutiny committee also takes into account, that the headmaster was misleading the board, the department, everyone, So therefore, this report, this report is also comes under that purview, The department was being misled, And this is a district level
At 2
scrutiny
o'clock,
committee, which is authority,
have this.
Diploma.
2013 notification, 30 January 2013.
And whether this committee is the same, that
Yes,
Number 11.
at 2 o'clock.
Second.
Let's let them start my senior counsel.
Lordship, my senior is on legs. Kindly
Then pick it up at 2 then.
Seven and eight. Seven and eight.
Yes.
Please, your lordships. My lord, there is an issue has been raised regarding maintainability of my petition, my lord. Lord, for my personal, my lord, difficulties, I could not prepare it, my lord. May I, my lord, pray for a short adjournment, my lord?
You are raising the plea of maintainability.
My lord,
We have
last
raised a
time.
question of material.
In my petition, my lord, 1361.
Okay, it's not well.
My lord.
When? Give us a date.
Lord, after 10 days, my lord,
Fourth of May.
9th of May. I got the numbers.
Fourth of May.
On the ground of some personal difficulties, Mr. A.R. Bhuyan and counsel for the petitioner prays for adjournment to make his submissions on the preliminary point of maintainability. Mr. Upadhyay, sorry, Mr. M. Khan, counsel for the private respondent, and Mr. P. Sekhar, studying also for the higher education.
Government advocate.
Government advocate appearing for state respondents are present.
Right.
Next one is agreed to by both sides list on 9/5/2023.
My lord. Obliged, my lord.
But Mr. Khan, next time you'll have to start your arguments if you're raising a preliminary issue.
Yes, sir.
Nine and 10.
You're also there in the matter, Mr. Majumdar? You're also there in this matter?
Yes, in the earlier matter, I was there for the department, yes.
Secondary Education Department.
My lord. Time was lost.
Nine and
Please, your
10.
lordship. Your lordship, let the matter be taken up at 2 p.m. your lordship.
have to open the file. When,
You have to clarify.
when I have faith on the London Council, we don't have to open the file. So if the education department says that this is the competent forum, we record it. And once it is recorded, then for the second bench, we can't take a change in stand. That is the difficulty.
Okay.
Bless.
Yes.
11.
May I please? Speak? My lord, the petitioner before my lord is working as an associate professor in an institution called ABLAC, my lord. It's the Anandaram Borua Institute of Language, Art and Culture. Now, my lord, here the facts situation is like this. He was a confirmed employee in Dibrugarh University, Department of Asmis.
Okay.
And my lord, he was confirmed in that post on 7/12/2011. Asmis Department in Dibrugarh University. Thereafter, my lord, he was inducted as a member of the Academic and Research Council of this institution. That is, my lord, Anandaram Borua Institute of Language, Art and Culture, Assam. Thereafter, my lord, one post of associate professor was advertised. He was an assistant professor. One post of associate professor was
Here, give me the dates again.
Lordship.
This.
My lord, he was an employee of he was an assistant professor in the Department of Asmis in Dibrugarh University.
Yes.
Thereafter, my lord, he was incorporated as a member of the Academic and Research Council of ABLAC. I'll call it ABLAC, my lord, Anandam Borua Institute of Language, Art and Culture. My lord, on 9/8/2012. And he was working there.
9/8/2012.
Lordship. It's basically a language research institute, my lord. And there are letter of appreciation and all. That's not relevant, my lord. Thereafter, the post was advertised on 28/2013. Page 36, my lord.
Page 36.
He applied through proper channel. And my lord,
What post?
associate professor in, my lord, language and linguistics. And then, my lord, on 19/2/2015, on his selection, he was appointed. My lord. My lord may have that at page 39. My lord. My dear.
Yes.
My lord, the appointment letter, my lord, would find at page 39. That refers to an agreement. That agreement, my lord, would find at page 40. He was given the continuously drawing the UGC scale in Dibrugarh University, and here also, my lord, the UGC scale was given. That my lord would find at page 40.
Yes.
Number 1 is not relevant. That's the UGC scale. Number 2, my lord, this is relevant. The party of the first part will be on probation for a period of 1 year with effect from the date of his joining. So this is the maximum period of probation that has been prescribed. That is 1 year. And my lord will not find any other condition in the subject to what the other side may point out. There is no other condition in this with regard to confirmation.
Tenure of 1 year.
1 year, my lord. Associate professor level. And they say, however, the services of the party of the first part will be subject to continuous appraisal by the executive committee of EBILAC. Then, my lord, the party of the first part may leave the assignment within 3 months notice to the second part, and likewise the part of the second part may also terminate the services of the party of the first part with 3 months notice. So, my lord, this when read with 2, it's within that probation period. They can, my lord, due to unsatisfactory service, without imputing anything, they can ask me to go, my lord. Now, what had happened, my lord? At page 42, I completed, my lord, 1 year on 18/2/2016. Or, my lord, a little bit thereafter. Then, my lord, at page 42, a certificate was issued to me, and therein, my lord, would find this is to certify that Bhaskar Jyoti Sharma is a permanent employee of this institute. He has been residing so and so within the campus of the institute from so and so since 1st April 2015. They have now, my lord, disowned this, saying that this authority did not have the authority to issue this letter.
Definitely, FAO will not have the authority.
I'm not on that. I'm only on the fact, my lord. I'm only on an existing fact that has been disclosed in that letter. I'll prove that, my lord. I'll take my lord further. Then my lord would see 43. When the director was not there, I was asked to take over charge of the post of director. Now starts the, my lord, problem. (10/10/2017), page 44, my lord. My lord would, this is the first letter that was given to me, 10/10/2017. In pursuance of the decision of the executive committee held on 19/9/2017, White Para 7(2), I am directed to inform you that your services is no longer required in EBILAC. As such, you are hereby discharged from service with effect from that is 11/10/2017 forenoon, and you are you have to vacate the residential quarter of so and so within 15 days. As per clause 3 of the agreement signed between you and the institute, 3 months salary is offered to you in lieu of 3 months notice, and salary will be released to you as soon as you vacate the official residential quarter of EBILAC. Now, my lord, my case here would be twofold. One, that on this day, 10/10/2017, I was no longer a probation member, because there is no order extending my probation period. So you could not have discharged me in the manner you are trying to do it now, because the executive committee's decisions were not before me, at that point of time.
There are Supreme Court judgments and even
It's from 1968, the full bench of the Constitution bench judgment I'll place, my lord, on this point.
also judgment of this court, this bench also.
There are, my lord, but every case has to be seen in the fact and situation arising therein. There are actually 3 lines, my lord, of cases. One, wherein, my lord, there is a period of probation given with a power of extension.
On this point, you and Mr. Chaudhary both together had cited, I think 22 or 24 decisions before me.
In that my lord, case of that Sharma, ki Sharma is it?
Pallavi Sharma.
Pallavi Sharma, my lord, in that case of the APSC matter, my lord.
Whatever way, but
Here, yes,
two together.
therein, my lord, why my lord what had distinguished that cases was on the ground that in Pallavi Sharma's case, APSC rules or the ACS rules or the APS rules requires an order of confirmation. A positive order of confirmation. They say a period of, my lord, probation is there, followed by an order of confirmation, because there are tests and trainings to be passed. Without that order of confirmation, my lord, I cannot be deemed to be a confirmed employee. So my lord held against us. If there is nothing, I'll show my lord. If there is only a period of probation given and thereafter there is nothing, then my lord, it would be deemed confirmation. So there are three lines, separate lines in this connection, my lord. Here, this was the order passed to me. Then, my lord, making a challenge to this, I filed an appeal, my lord, at page 46. I am showing the handwritten one, my lord, with a reason.
Page.
Page 46, my lord. Against this order of 10-10, I preferred an appeal on, my lord, 11-10-2017 when it was handed over to me.
Yes.
As you may be aware, I have been told that my services so-and-so is discharged with effect from today, October 11, 2017, without elaborating on the causes leading to such a drastic decision. That spelling is wrong, my lord. My lord will only make a note of this. As I have performed with utmost sincerity and efficiency and completed all responsibilities given till now, I am indeed shocked to receive such news. I therefore request you to kindly consider the matter seriously and discuss it rationally amongst other members of the executive committee to come up with a sensible decision. So now what they have done, my lord, in the affidavit, if I can have my lord's attention to the affidavit that has been filed. So in the meantime, my lord, on 30-10, this writ petition is filed before that. On 30-10, this matter is considered. On 30-10, this honorable court passes an interim direction. If my lord can just have that order dated 30-10-2017.
Yes.
My lord will have the third paragraph, fourth paragraph.
Yes.
Materials available on record prima facie indicates that the order dated so-and-so has been issued in violation of the principles of natural justice. Then, my lord, towards the end, having regard to the facts and circumstances of the case, it is provided that operation of the impugn order dated 10-10-2017 shall remain suspended until further orders. Consequently, the petitioner shall be allowed to continue in his present post and also to occupy the residential quarter without any hindrance. So this was the order passed. Now, my lord would have the minutes of the executive committee meeting, basing on which that 10-11-2017 order was passed. 10-10-2017. That my lord would find in the affidavit filed by the respondent number 2, 3, and 4 at page 12 thereof.
Just a moment.
Sorry. My lord, the running page numbers are not here, so my lord, it would be slightly difficult for your lordship to point out. There is an affidavit and there is a counter affidavit. Counter affidavit is filed on in the month of September 2018. If my lord can have that.
Of IA, your lordship, of IA. IA percent. 19 minus 5.
18 or 20.
There's one affidavit filed and reply. Filed on
Reply is there,
7-8-2018.
lordship. That is mine,
There's a counter affidavit on behalf of respondent number 2, 3, and 4
lordship,
by one Dilip Kumar Kalikar.
lordship. That one, my lord, will come to page 8. That's the minutes of the meeting dated 19/9/2017.
Yes.
My lord, this is a minutes of the executive committee meeting held on 19/9/2017, 2:30 PM, so and so. So this is the minutes which is reflected in the order in the communication dated 10/10/2017. My lord would come to the page 10 thereof, para 7. Page 10. It starts at page 8. I'll have my lord's attention at page 10, para 7. Now, my lord would mind, let's hold for a second that I'm not a confirmed member. I'm a probation for a second. Although I'll try to justify that I'm not a probation. So the agreement says that my service will be continuously monitored. Fine. If you find anything shortcoming in my service, nothing to say. My lord will come to para 7. The director placed before the meeting the fact that there are 6 new incumbents and the UDA in the institute whose posts are yet to be confirmed. The meeting took up the incumbents' cases one by one and decided as under. The performances of so-and-so as apprised by the director is not satisfactory at all. What was the material one? No, nothing disclosed. And my lord will read further. And there are allegations of misbehavior and repeated quarreling from other members of the staff, which is unbecoming of a person of a stature of an associate professor of a respectable institute like EBILAC. My lord, this itself is stigmatic. This itself reflects that the order is punitive in nature. My lord need not even go a step further. Although I'll show my lord the second subsequent notification. If there is anything reference to my conduct during my service career, that my lord will have to be subjected to a proceeding under 300, Article 311. It cannot be done otherwise. If you had said that his services are not satisfactory, materials had been placed, and that too, how it is to be done, the Supreme Court has said that you have to give him a notice saying that, see, you have been working here, we have not found, because of this reasons, we have not found your service to be up to the mark. Kindly improve, or we will take steps. It's only thereafter that you can go for a, my lord, a proceeding for, or an order passing, discharging the probationer on, my lord, unsatisfactory ground. That is not even the ground taken here. Here the ground taken is the allegation made by some other staff that I have the habit of misbehavior and repeated quarreling. My lord, this fact, this issue was never even tested, my lord. Because this will be a stigma for me in all my life, all through, my lord. And then what they say, my lord.
Unless you attach this with your CV.
Because, my lord, it's not that. Tomorrow I go, I apply for an employment in some organization. The organization, I'll say I was discharged from here. They will write, man. That's the place how it comes out. They will write to the institution that how have you got it? Why did you ask him to go? So this would be the material there, my lord, which would be communicated, and I'll never be employed. That is why the test of stigma, my lord. The meeting unanimously resolves that Dr. Bhaskar Jyoti Sharma be discharged from service with immediate effect with reference to clause 3 of the agreement signed by him in the institute. He is to vacate the quarter of EBILAC within 15 days, which is occupying at present. The meeting also resolves that 3 months salary be awarded in lieu of 3 months notice, and his salary be released to him after he vacates the residential quarter of so-and-so. The meeting also directs the director to serve the discharge letter on so-and-so at the earliest. So, my lord, the director placed some material, which is nothing but, my lord, allegations against me. So, if you are basing it on an allegation, the foundation is on the allegation, then, my lord, you cannot discharge me, even if I am a probationer, without subjecting me to a proceeding, my lord. Then, my lord, what happens? my lord, make an appeal before them. That appeal which I have taken my lord through. Now my lord would see how that was dealt with. For that, my lord will have to take the trouble of coming back to the the affidavit file. First affidavit. Page my lord 13 of that affidavit. First affidavit of 6/6/2018.
Yes.
My lord now would see this meeting was specifically called to consider my that appeal. Para 4, my lord, at page 30. The application was read out in the meeting, which reads as follows. The application, my lord, is quoted here. Thereafter, my lord would see. They have, my lord, in bold, they have made my mistakes, my lord, clear. The application was scrutinized. My lord, page 14, the paragraph after the quoting. The application was scrutinized by members and expressed surprise at the academic poverty of the applicant and volumes of mistake in the short application. The members also expressed amazement at the ignorance of the name of his department of the applicant and questioned as to how a person can claim to be working sincerely while he has not cannot write the name of his department correctly. A man's, my lord, livelihood is gone. He is under that mental condition, and see how they are considering that application, my lord. The members expressed their view one by one. So-and-so was not present in the last meeting, wanted to know if show cause notice was required before termination. The director explained to him that appointees at so-and-so signs an agreement while joining the institute. The agreement contains a clause which reads that under. My lord can ignore that and come to page 15, my lord. Dr. Goswami then gave his opinion. And he raised the question since he did not know about this clause of the agreement and agreed that this clause provides for termination without show cause notice as the performance of the applicant was very poor, which is evident not only from the report given by the director, but also from the sheet showing list of works done by the applicant. Taking part, then, my lord, they goes English language. They say, I'm a Smith thing, my lord. I'm not an English, I'm not a MA in English or a slate in English, but I'm a Smith department person, my lord. Then they say the only modification they make is, my lord, that 3 months notice.
And some Hitler pointed a gun and he had to write in English.
So when my lord is with that affidavit, my lord will see the contentions therein. And then I'll take my lord through the judgments. My lord would come to para 3, my lord, at page 2. So the basic decision is in the first meeting, 1909, wherein, my lord, there is nothing with regard to my service, but with regard to my conduct. My lord will come to page 2.
It's surprising when you are in the English language. Why you did not say this? I don't know. Page 14.
Of the writ petition, my lord?
No.
Of
You
that,
were just reading that page 14. There's some word written in a bracket. You did not notice that. There's a word written in bracket.
Abilec. Sorry, my lord. The words in italics are supplied by the applicant.
Not italics. Bracket.
Sincerely. That's also a spelling mistake, my lord.
Why do you have? How would you omit that?
How? And they have written it. The learned people.
No, but you missed it.
I missed it. Sorry, my lord. I missed it. My lord.
So you miss the bus, not they.
I'm reiterating that, my lord. So English language is, and my lord would see how the manner of consideration. I'm not saying I'm the most best person there. But when you consider me in terms of the act. Natural justice has to be given to me, my lord. Now, my lord comes to the affidavit at page 2, my lord. Third paragraph. Para 3, my lord. The second line onwards, my lord. As per
Which one?
clause 2. Page 2, my lord, of that affidavit.
Yes.
My lord, here my lord would find the second line. As per clause 2 of the agreement dated so and so, the petitioner was on a probation for a period of 1 year with effect from the date of his joining, and his service was subject to continuous appraisal by the executive committee of EBILAC. My lord, from 2015 till that date when the meeting was held, I have written it in my reply. There was nothing of this sort done against me, my lord. Nothing was found adverse against me. The performance of the petitioner was found very poor, and moreover, he was found to be negligent in his duty. The clause 3 of the said agreement stipulates that the respondent may terminate the service of the petitioner with 3 months' notice. The executive committee, having not been satisfied with his performance of the petitioner, my lord would see, not satisfied with the performance of the petitioner, the resolution for discharging the petitioner from service was unanimously taken on 19/9/2017. My lord has gone through that decision. There is nothing indicating that why my services were not satisfactory. What was there was my conduct only, which again was never put to me. And my reply to that is in paragraph 5 of my reply. My lord need not even go into that. I'll have my lord's attention back to that counter affidavit now. At page 2 thereof. Paragraph 5, my lord may make a note of this, that the statements made in paragraph 5 of the affidavit in reply are not true and correct, and while not admitting the same, the statements made in the affidavit in opposition are reiterated and reaffirmed. The deponent further begs to state that the job performance of the writ petitioner was not satisfactory. There was continuous performance appraisal from the date of joining of the writ petitioner in service. Such, my lord will note this words, such appraisal is a confidential vote, and there is no question of disclosing the same to the writ petitioner. The executive committee had gone through the appraisal report and came to the decision to discharge the writ petitioner from his service by resolution number 7 of the executive meeting held on 19/9/2017. The executive authority committee is the competent authority to take decision for termination of service of the writ petitioner in terms of the agreement dated so and so. It is further stated that the agreement dated so and so does not contemplate the issuance of any notice to the writ petitioner regarding the deficiency of service. As such, there is no question of serving a notice to the petitioner regarding his deficiency in service. So, my lord, they have said there was no notice given to me at any point of time, highlighting my deficiency in service. Some report was placed in a meeting which I have questioned. My lord said that the persons were not there because the signatures of the members present were never brought on record. It's only the chairman or the director who has signed the minutes. The others were not there. This whole game, my lord, was played by the director. He does not want me there. There are reasons for that. He does not want me there, but that's, my lord, I'm not going because I've not made him my name party. I'm not going into that. But my lord, legal malice is true. Firstly, in the first meeting, you say my conduct, I have done misbehavior. I have been quarreling with the other employees who have complained. Now, if that be so, my lord, that is an imputation of, my lord, misconduct. If it be an imputation of misconduct and basing on that, you have terminated me, then, my lord, a simpliciter, termination simpliciter will not lie. It has to be followed by a proceeding. My lord. It has to be 311, Article 311 has to be complied with. Principles of natural justice have to be given to you. And lordship,
Yes.
and lordship, whatever is stated in the affidavit, the developments that are made in the affidavit, my lord will have to examine it in the light of the materials available on record. If the records per se does not disclose us, they may not be permitted to develop their case. My lord, that I did not place any judgment. My lord, development of a case by filing affidavits is of no use, my lord, if the original order does not speak for itself. Now, my lord, the original order is vague. It only says that my services are being discharged. My lord is lifting the veil to understand the reasons behind this. And once the veil is lifted, my lord, and my lord examines the 19/9/2017 minutes, my lord would find that it's based on an allegation where there is no foundation. They have founded the discharge on allegations which have not been verified. But they have used it, my lord. Stigma. Second, they say my services were being continuously being appraised from 2015 to 2017. Those materials were never made part of the proceedings. What are the materials with them? Because the executive committee meetings must reflect, because they say continuous appraisal. In the affidavit also they say, my lord, it was being continuously appraised, but it's confidential. We have not disclosed to the petitioner. At para 5 of the counter affidavit. It's very categorical that there was continuous performance appraisal from the date of joining of the petitioner in service. But they say it's confidential, so we are not disclosing it. So, my lord, this is the factual matrix in which the case is there. Now, my lord would find, just to sum up the facts, my lord. One, I was appointed with a condition that I'll be on my lord probation for a year. There was nothing thereafter. I was not required to pass any test. There was no order required to be passed confirming me in my service. So, my lord, it's deemed appraisal. There was a condition, there was a line there. However, my services would be subject to continuous appraisal. In 2017, September, all of a sudden, my lord, they take up the matter and they say that the director has said your services are poor, are not satisfactory. And You have been acting unbecoming of your career of a person who is to be appointed as a associate professor. You have committed misbehavior. You have, my lord, quarreled. This is the allegation we got. So we don't require. Now they come back and say in paragraph 5 of the counter affidavit that this appraisal was being made every year right from the beginning. But these are confidential and need not be, my lord, given. Now, my lord, I'll take my lord through the judgments. First, my lord, the deemed confirmation thing, my lord.
Just one.
Lordship. GSM.
Yes.
Now, my lord, I have given this judgment. First, I'll, my lord, place the judgment with regard to that deemed confirmation partner.
Jairam Dayal.
Lordship.
Jairam Dayal.
Dharam Singh, my lord. First, Dharam Singh. That's a constitution bench judgment. My lord, it discusses all the earlier Supreme, even Samsher Singh and all. And then, my lord, Sukhban Singh and all. My lord may come to.
But in this, both these cases, there is a distinguishable point. You'll have to meet that also.
Lordship.
You see, apart from being this, what do you call, employment by way of an order by the authorities, your appointment is also covered by an agreement. So agreement, I don't think in this Dharam Singh and.
My lord, lordship,
they are-
lordship, it's not there. My lord, the law as it stands today is that the service rules will hold the field. It will be the thing which will have the primacy. In absence of a my lord service rule, then the executive instructions will take its place. Here there is an agreement. That agreement says it's only for 1 year. I would put it in a more higher pedestal. Because both of them were added in that this probation period, because it's an associate professor, it's not an assistant entry level mother, it's in a higher level. So that you will be on a probation for 1 year. So that probationary period is 1 year and 1 year only. You will have to assess my thing within that period. And if you don't find me suitable, ask me to go, no problem. But once I have completed that period, you cannot take the plea of my unsatisfactory period during that 1 year and then come back and say that now that you are unsatisfactory as a probationer, we don't want. That's exactly what, my lord, this case of the Punjab case, my lord, Dharam Singh says. I'll place that, my lord. Para 5, my lord. Para 5. In the present case, Rule 6.3 forbids extension of the period of probation beyond 3 years. Whereas in the present case, the service rules fix a certain period of time beyond which the probationary period cannot be extended. And an employee appointed or promoted to a post on probation is allowed to continue in that post after completion of the maximum period of probation. Without an express order of confirmation, he cannot be deemed to continue in that post as a probationer by implication. The reason is that such an implication is negativated by the service rule forbidding extension of the probationary period beyond the maximum period fixed by it. In such a case, it is permissible to draw the inference that the employee allowed to continue in the post on completion of the maximum period of promotion has been confirmed in the post by implication. So, my lord, here there is an agreement between the parties that you will be on probation for a period of 1 year. Thereafter, my lord, there is nothing on record to show that there was a further agreement for extension of the probationary period. They could have done it. There is no bar in that. Now comes the letter of the FANCU, wherein he says, I am a permanent employee. That has significance. That letter might not have been issued, my lord, in the normal by an authority competent enough, but it says an existing fact, my lord. It brings on record an existing fact. And the existing fact is that I am a permanent employee on that day. Now, my lord, here, if my lord goes, I'll not trouble your lordship with the facts. My lord will only turn over to my lord 7 lines about paragraph 7. My lord.
Yes.
But the authority allowed them to continue in their post thereafter without passing any order in writing under 6.3. In absence of any formal order, the question is whether by necessary implication from the proof facts of this case, the authority should be presumed to have passed some order under Rule 6.3 in respect of the respondents, and if so, what order should have been presumed to be passed. Now the reply, my lord, would find in paragraph 9. Immediately upon completion of the extended period of probation on so and so, the appointing authority could dispense with the services of the respondent if their work or conduct during the period of probation was, in the opinion of the authority, unsatisfactory. Instead of dispensing with their services on completion of the extended period of probation, the authority continued them in their post until sometime in 1963 and allowed them to draw their annual increments of salary, including the increment which fell due on October 1, 1962. The rules did not require them to pass any test or to fulfill any other condition before confirmation. There was no compelling reasons for dispensing with their services and re-employing them as temporary employees on so and so, and the High Court rightly refused to draw the inference that they were so discharged from service and re-employed. In these circumstances, the High Court rightly held that the respondents must be deemed to have been confirmed in their post, though the appointing authority did not pass formal orders of confirmation in writing. It should be presumed to have passed orders of confirmation by so allowing them to continue in their post after October 1, 1960. After such confirmation, the authority had no power to dispense with their services under Rule 6.3. October 1, 1960. After such confirmation, the authority had no power to dispense with their services under Rule so and so on the ground that their work and conduct during the period of probation was unsatisfactory. And thereafter, my lord, the orders were interfered with. The second case, my lord, would find Dayaram Dayal. I'll have my lord's attention at para 7. My lord, this explains the various facets in a deemed confirmation and probationary not confirmed, my lord, scenario that deals with PMI. Para 7. An examination of the rulings of this court on the question of probation and confirmation shows that in some cases this court has held that mere continuation beyond the period of probation does not amount to confirmation unless the order of appointment or rule contains a deeming provision, which in some other cases it has been held that in certain exceptional situations it is permissible to hold that the services must be deemed to have been confirmed. We shall show that there is no real conflict between the two sets of decisions, and it depends on the conditions contained in the order of appointment and the relevant rules that are applicable. My lord, will only mark that. One line of cases has held that if in the rule or order of appointment a period of probation is specified and a power to extend probation is also specified and the officer is continued beyond the prescribed period of probation, he cannot be deemed to be confirmed. And there is no bar on the power of termination of the officer after expiry of the initial period of probation. In the case before the Constitution Bench of this court in Sukhbans Singh versus State of Punjab, Rule 22 of the relevant rules provided a period of probation and contained a provision for extension of probation. Rule 23 for termination during probation and Rule 24 for substantive appointment on completion of probation. It was held that a probationer cannot automatically acquire the status of a permanent member of the service unless, of course, the rules under which he is appointed expressly provided for such a result. The rules governing the provisional civil services of a Punjab do not contain any provision whereby a probation at the end of the probationary period is automatically absorbed as a permanent member of the civil service. Then, my lord, it says, it discusses 2-3 judgments. My lord may come to para 9, which is my lord case. Wherein, my lord, Dharam Singh has been considered. The other line of cases are those where while there is a provision in the rules for initial probation and extension thereof, a maximum period for such extension is also provided, beyond which it is not permissible to extend the probation. A question as to its effect arose in the Constitution Bench in so and so. The relevant rule therein provided initial period of 1 year and then for extension subject to maximum of 3 years. The petitioner in that case was on probation from so and so for 1 year and was continued beyond the extended period for 3 years and terminated in so and so without any department proceeding. A constitution bench of this court in so and so cases distinguish the same as cases where their rules do not provide for maximum period of probation. But if the rule, as in the case before them, provided for a maximum, then that was an implication that the officer was not in a position of a probationer after expiry of the maximum period. The presumption of his continuing as a probationer was negativated by the fixation of a maximum time limit for the extension of probation. The termination after expiry of 4 years, that is after the maximum period for which probation could be extended, was held to be invalid. This view has been consistently followed in so and so, which are all cases for a maximum period of extension of probation was prescribed, and termination after expiry of the set period was held to be invalid in as much as the officer must be deemed to have been confirmed. My lord, will have para 13, my lord, the conclusion. That 3 months notice period that was given to me, my lord, whether that is valid, this paragraph will answer that one. It is therefore clear that the present case is one where the rule has prescribed an initial period of probation and then for extension of the probation subject to a maximum. And therefore, the case squarely falls within the second line of cases, namely Dharam Singh case. And the provision for a maximum is an indication of an intention not to treat the officer as being under probation after the expiry of the maximum period of probation. It is also significant that in case before us, the effect of the rule fixing a maximum period of probation is not whittled down by any other provision in the rules, such as the one contained in Samsher Singh's case or in Ashok Kumar Mishra's case. My lord, if I may pause here for, there was requirements therein that there should be a positive order of confirmation. So that was distinguished. Now, my lord, though a plea was raised that termination of service could be effected by serving 1 month's notice or paying salary in lieu thereof, there is no such provision in the order of appointment, nor was any rule relied upon for supporting such a contention. Now, my lord reads this with Dharam Singh, the concluding paragraph, wherein it says that any unsatisfactory service during the period of probation, you cannot after that period discharge the person, basing on that. So, my lord, after 1 year, I was deemed to be, my lord, confirmed. And accordingly, my lord, the discharge as a probationer, in my case, is not attractive. Now, my lord, a question may come up, my lord, that maybe there is a gray area here, whether I am a probationer or a confirmed employee.
Just a moment. Where is that agreement? Which page?
Which one, my lord?
Page 40. Was that agreement?
Lordship. The agreement, my lord, would find.
Page 40.
40, my lord. Very categorical.
Okay.
Now, my lord,
I'm reserving one question which I'll ask after Mr. Chaudhary makes his argument.
my lord, it may not be completed today because Mr. Chaudhary will also apply. I'll keep my second limb, my lord, in reserve. If your lordship can fix it on
No,
a,
no, don't keep it patterned.
because my lord, I don't think so it will be finished, my lord, because he's on legs in court number 6. It may not be problem. It may be, I won it.
Your lordship is talking report number 6.
6, my lord. That's why I said. My lord has got it. I'll take another 20, 25, 30 minutes, my lord, or maybe hardly 45 minutes.
Because pattern I'm not trying to keep.
My lord, he'll keep it for further hearing, my lord.
Fix it some other day then.
Lordship.
I have difficulties. There are few
Can you
matters
come
I
back
have
to your lordship, my lord? He'll only keep it for further hearing. Don't keep it for part, my lord. My lord will keep it for further hearing. My
No, further hearing is.
lord. Effect will be the same.
No, no. I'm not keeping pattern.
My lord will not keep it part. My lord will keep it for further hearing. This bench is continuing, my lord. Next week, any date, my lord. Because I'll only have to now place before my lord that considering myself to be a probationer, whether this termination would be valid. That I'll place, my lord.
No, that is okay, but if it's not being completed, I'm not keeping it. I have some.
My lord, need not. My lord, need not.
What do you call it?
Because I don't want to wait further time because my lord, he may not come up, so it may not be complete today.
No. Just 15.
My lord will only fix a date, my lord, whenever it's convenient. to your lordship.
We can not 10-5 then.
Lordship. 10-5, no problem. my lord. It would be a
Wednesday.
Wednesday. Or 9-5, my lord. if
Your
not-
lordship 9-5.
No, I have a election matter fixed on.
Okay. Then let it be on 11th, my lord, if it's my lord board is empty on 11th. Empty on 11th.
Okay, 11.
11th.
Both sides are duly represented. As agreed to by both sides, list for hearing on
11-5.
11/5/2023.
Lordship. Hopefully it comes back before your lordship only, then 10-15 minutes I'll have to take one.
No, because I have
I understand.
few things
My lord
on
would have
board.
had a very hard time, my lord. Now. But still a gray area is there, my lord, in this. There are few judgments I'll place, my lord. with that. But constitution
Gray-
bench
gray
judgment
area is-
still holds.
Gray area is limited. Empty area is
That
more.
is here, my lord. That, not that side, this side, my lord.
Empty area is more.
That's better, my lord, so you can expand. Much obliged.
9 and 10.
Wait, your lordship. Well, I am saying in item number 9, my lord. My lord, the matter relates to my lord, the appointment of LP school teachers, my lord, on contractual basis.
My lord,
And there are,
in
my
this
lord,
case, my lord,
11,000.
Lanet AG will appear, my lord. So matter may come out another day, my lord.
He's not arguing today.
No, my lord, some difficulties there.
My lord, may I point out one thing, my lord. In this matter, my lord, we have challenged the recruitment of 11,319
On 9th.
teachers, my lord.
9th or my lord,
11,319 numbers of teachers, my lord, without issuing the advertisement, my lord. But my lord, we have not made them party responding in an instant case, my lord. But my lord, we have made a statement, my lord. If we are kindly be allowed to issue public advertisement, my lord. So that my lord, they make him represented in this case, my lord. At paragraph 10, my lord, we have made a statement, my lord.
Not today, my
Paragraph
lord, it's a
10, page
long
54.
pending case, my lord.
Page 54, my lord. Paragraph 10. May I read, my lord?
But you see, I have some difficulty in considering the prayer. You see, there are two things. Number one, this writ petition is pending since 2019.
Yes, ma'am.
So therefore, it would be appropriate if you file a interrogatory application for this prayer. That's number one.
My lord.
Second is, you see, every day newspaper comes to me. But this columns in newspapers where classified advertisements are given. I have read somewhere it is called agony column. Correct. But I never read those columns to see whether in any case I have been implicated as a respondent and I have to go and appear in the matter. Because you see, subject to how you convince the court. My idea is that when you use order 5-20, which is substituted service, an attempt must be made first to make service to the by usual process. And only then there can be a substituted service when the court records a finding that despite service, the man he's trying to avoid service or he has been served and not appearing. So therefore, you see, if we permit you to put an advertisement for 11,000 employees, 11,900 odd people, how do we expect that they will read this newspaper and then come to understand that the challenge is made to their appointment? This is something you have to convince me.
In that case, my lord, can we file an interrogatory application, my lord?
No, you do it, but this is a question. If it comes to this bench, I'll have to ask you this. You'll be prepared for that also, my lord.
On the next occasion, my lord.
Because every day at least I read newspaper,
Yes, my lord.
but I don't
Those
read those
columns
agony
will-
columns just to see whether I have been implicated by someone by name and I have to respond to that. So because newspaper service, does a High Court rules provide that? Without impeding, can somebody be asked to contest? I don't think our High Court rules permit that.
Then, my lord, can we make a prayer, my lord, to take steps to the mission director, my lord?
These people are not before the, as respondents now.
Yes, ma'am. These are not.
These are not
before us,
respondents now.
yes.
I'm just, on your prayer, I'm adjourning it. I'm not saying anything.
My lord.
Uh, On the prayer of, Midwest RM Cabinet Council for the petitioners. The matter stands adjourned today to enable him to file an appropriate application. Mr. P. Bharat and standing host for the Elementary Education Department is present. List after?
2 weeks, my lord.
List after 2 weeks.
Obliged, my lord.
May I please the lordship?
Yes,
I am in item number 10, my lord, for petitioners. Similar situated matter, my lord.
okay. That's right. Your name?
Arthur,
Ardas.
on behalf of
Second
their
item.
lordship.
Same order.
And another prayer, your lordship. Our name is wrongly mentioned in respondent column, your lordship. It should be on petitioners column. On item number 10.
You're not for respondents.
No, no.
Mr. Ardas, Learned Counsel for the Learned Counsel submits that he is appearing for the petitioner, but in the cause list, he is wrongly shown to be appearing on behalf of respondent numbers 1, 2, 5, 6, 8, 16, 17, 18, 20, 21. So accordingly, the registry shall reflect the name of Mr. J. Laskar
James.
and Mr. Ardas as counsel for the petitioners. And who are these SK Talukdar, GMA Chaudhary, they are for?
They are also for the petitioners, your lordship, other petitioners. Others petitioners. We are
No,
not
how-
for all the other.
How can that be?
Petition for I cannot
In a rate petition, you can't appear separate for separate petitioners. That is not permissible.
It is, I am not clear, your lordship. We are for 1, 2, 5, 6, 8, 16, 17, 18, 20, and 21. Me and their lordship.
I'm not getting it. You are for respondents or you are for petitioner?
Petitioner, your lordship, in item number 10.
petition. Hotel prisons.
Second file. No, but then I'll put an observation in the order. This can't be permitted. In one rate petition, you can't appear for one set of petitioners and the other set for another set of by another set of counsel. That is not permissible.
My lord, here, my lord, item number 10, usually my lord, SK Talukdar appears, my lord.
No, I don't know, but he has filed a wakalatnama for 10 people.
Let my lord, SK Talukdar appear before this court, then it will be clear, my
No,
lord.
I don't know. Whatever is there before us, we'll record that.
My lord.
Just strike that out, huh? It has been brought to the notice of the court by Mr. Ardas, Learned Counsel, appearing for petitioner numbers 1, 2, 5, 6, 8, 16, 17, 18, 20, and 21. That in respect of the said petitioners, he along with Mr. J. Laskar are appearing by filing a wakalatnama on 2/2/2023. Full stop. On the next date of listing, or the learned counsel for the petitioner shall apprise this court as to whether there is any provision in the High Court rules to permit two sets of counsel to appear for different petitioners, and whether it will be permissible for the court to hear two sets of counsel in a common writ petition. Full stop. Nonetheless, the petitioners who are appearing separately by through a second set of counsel are at liberty to withdraw themselves from the writ petition and to approach this court by filing a separate writ petition. Full stop. The observations made in this order is only tentative and shall be heard on the next date. Mr. P. Barwar and standing counsel for the Elementary Education Department is present. List after 2 weeks.
Bless you.
In your case, we are not fixing it for that leave to file affidavit. This is certain, you may take a contrary stand. You may take a contrary stand to what the petitioner, other petitioners are arguing. We can't permit that.
I need to obtain some instruction.
Now you do it because this I have already penned down in my order. We can't hear two set of counsel in one writ petition.
My lord, the matters will be taken together, my lord, 9 and 10.
It is together, but in your case, I have given that liberty to file a petition.
My lord,
In his case, that I have not given.
my lord. My lord, may I pay for a date, my lord, pay for after 2 weeks.
You said 2 weeks.
Yes,
You
sir.
file it because it will be an interrogative application to
Yes,
come along with that.
I am obliged.
Item number 2,
In this case, my lordship has directed Mr. R. Mujumdar to bring some instruction. My lord. He has not received yet, my lord. So any date may be fixed, my lord.
Next paragraph. None appears on call for the petitioner. It is seen that by order dated 27/3/2023. The court had a query as to whether the post of second grade 4 employee to which the petitioner claims regularization exists in the concerned school or not. So on such query, the learned counsel for the petitioner had prayed for some time to address the court. Next, whereas the learned counsel for the petitioner is absent on call, Mr. I'll record his name,
R Muzumdar name will be recorded.
Mr. R. Mazumdar on council for the secondary education
My
department.
lord,
This is secondary,
my lord.
shall obtain the requisite instructions. Mr. Florence Justice, the magistrate Judge John today. List on, give a date after 2 weeks. 15/5.
God bless.
Anybody is present for part 2? Any matter where both sides are present? Part 2.
I am for 87.
Other side is present.
No, but
If you can get the other side, we can take it up. 87.
87.
Who is for the other side? If you can find them, you can please bring it. I'll come back. If in any case both sides are present, please call me. I'll come back. Otherwise, I'll rise.